네, 안녕하십니까.
Good morning, everyone. Good morning. It's so pleased to see you. International Conference on the Earth Jurisprudence 2023. Thank you very much for coming here today. I am Kim Bomi, who is working for the Pro Bono Center Sun, and I'm an attorney. People for Earth has invited the experts about the Earth jurisprudence, and this has been hosted by the Pro Bono Sun and the Law Partners One, and the People for Earth are co-hosting this event celebrating the 10th anniversary of the Sun Pro Bono Center. And as you may understand, Pro Bono Center Sun has been working with the People for Earth starting from 2015, and we have been providing the credit system that has been recognized by the Korean Bar Association, and we have been providing the lecture for the Earth Jurisprudence. We are providing simultaneous interpretation for English and the Korean, Channel 1 for Korean and Channel 2 for English. And you can tune into the preferred language you'd like to listen to. After the conference, please leave the receiver on your table. And we have 2 days of the conference on the 17th and the 18th of the November on the day 1. We're going to have the discussion under the topic of the Earth jurisprudence more than human. We're going to talk about the jurisprudence for the lawyers, Earth system governance and the law, and also we're going to have the research trends and the visions about the Earth jurisprudence. We are going to share our wisdom together on day 1 throughout the 3 sessions. On day 2, which is tomorrow, we're going to focus on the education and art for Earth. There will be a roundtable, and also there will be a short film preview, a story of the 2 women. Before we start the conference, I'd like to ask for your understanding. Our keynote speaker was Maria Mercedes Sánchez. However, her father passed away, and that is why she was not able to make it here today. And I'd like to deliver condolences to her and to her family. And also, I would like to ask for your understanding due to unexpected event, and there was a change in our schedule. We would like to deliver our sincere sorry to you, and I would like to ask for your understanding. And before we start the event, I would like to invite the managing partner Yoon of the One Law Partners. Please welcome managing partner Yoon with big hands. Morning, I'm Yoon, attorney at the One Law Partners. Welcome to the Earth Jurisprudence More Than Human Conference commemorating the 10th anniversary of the Sun Pro Bono Center. This is the 10th anniversary, so we wanted to celebrate this event along with many people. Usually, when you have the 10th anniversary and there is a huge ceremony, usually we eat together and we look back on the past. That's how we usually celebrate the 10th anniversary in Korea. However, considering the activities of the Pro Bono Sun, we have been focusing pretty much on climate change and the Earth's jurisprudence. That are the core areas. So that is why we wanted to celebrate the 10th anniversary of the Pro Bono Sun in a different way. To think more about the Earth and what are the key challenges that human being is now facing. I mean, the climate change. We should think more about the climate change and the urgent task that we are facing all together. That is why we are hosting this event. First of all, I would like to thank all the people who are gathered here today. Thank you very much for your presence, especially the Academic Society of the Earth Jurisprudence and the Pro Bono Sun are now hosting this event. Thank you very much for your presence and welcome all of you. According to a report, and I'm not the expert, this year was the hottest year since the last interglacial period, about 125,000 years ago. The global temperature continues to rise, as you may understand, and there are extreme weather events like droughts, typhoons, and heavy rains, and those extreme weather events continue to rise these days. The climate crisis becomes more serious, and we can feel the limitations of the existing legal system. Now we are more interested in jurisprudence or the Earth jurisprudence, which is a new approach on the law and governance that seeks after the well-being and the prosperity of the entire global community beyond the human community. And probably the Earth jurisprudence might be unfamiliar term to many of you. Of course, there are experts who are gathered here today, but we are at our infancy about studying the Earth jurisprudence. However, more and more people have interest about this new discipline, the Earth jurisprudence. Sun Pro Bono Center was established in 2013, and we have been following after the value for the social values, and we have contributed a lot to our society, especially to promote human rights. And there are around 10 law firms working for the public goods, and we are the only one that has carried out various public interest activities in the ecological and environmental fields. For example, we actively supported the judicial constitutional appeals of the youth related to climate crisis and constitutional appeals to call for climate disclosure and the climate response activities of the youth activities. The Sun Pro Bono Center has actively participated in activities to introduce and publicize the Earth jurisprudence to lawyers. And now many people who study law can understand the concept of the Earth jurisprudence. Since 2015, together with the People for Earth Foundation, we have been holding the Earth jurisprudence lecture for the lawyers every year as a training program recognized by the Korean Bar Association. We are very pleased to hosting this international conference today with the Academic Society of the Earth Jurisprudence. The Sun Pro Bono Center operates the Earth Jurisprudence courses and has continued to have close exchanges with the executives and the staff of the People for Earth and the Society of the Earth Jurisprudence. Thank you very much for your close cooperation. This conference will be a valuable opportunity to look back on the achievement of the Earth Jurisprudence Education Project and the public pro bono project we had. And For the experts from around the world who are interested in the governance and the Earth system theories together, so we can have a more interaction and we can share the knowledge. We'd like to express our sincere gratitude to everyone who attended the conference, both on-site and online, and hope you have a really meaningful time throughout this conference. Thank you. Thank you very much. Managing Partner Yoon, thank you very much. And I hope that the People for Earth, the Pro Bono Son, and the Society of the Earth Jurisprudence can work together to build a better world. Next, I would like to invite the President Kim Sang-yeop, who is the Commissioner for the Carbon Neutrality and Green Growth. I would like to invite President Kim Sang-yeop to the stage. I'm Kim Sang-yeop. Actually, I came here to study. I didn't expect that I'm gonna stand on the stage, but anyway, thank you very much. Minister Kang. I met Minister Kang in the Sustainable World Forum just a few years ago, which was hosted in Pyeongchang, and I had some interaction with Minister Kang. And also, I do understand the passion and the commitment of the people for Earth. And taking this opportunity, I would like to deliver my sincere respect to Minister Kang and People for Earth. And I got the book that has been published by the Society of Earth Jurisprudence. And I would like to deliver my sincere appreciation and respect to all the scholars, including Professor Kim Wang-bae. Thank you very much. Professor An, he's been a mentor to me. And he was invited to the EU, and he got lots of interest from the public. When I was working for the broadcasting company, and we had a report to cover the future of the Earth. In 2004, the topic was aging society. The aging society will have a significant impact on the future of the Korean society. That was the first report that I had in 2004. Now, many people were concerned about the aging society. However, Minister Kim Gun-tae back then watched our program and he took action. He met with the president and the population strategy and population policy was changed in Korea, and that is how we came up with the Presidential Committee on the Aging Society. However, aging society is a significant issue. The governance structure was really weak to tackle the aging society back then. The demographic change can be a huge challenge. In that case, we should have a really good governance. However, at that time, the Ministry of the Welfare was just taking care of that issue from the department level, not on the ministerial level. But for me, the climate change is a bigger issue. It is a much bigger challenge than the aging society because when the climate change is taking place, we cannot live on the earth. Aging society is something that you can deal with, but if there are some extreme weather conditions, we cannot live on the earth. That means we should have a bigger governance and well-established governance. However, the climate governance is not that strong, even though the importance of the climate change is really huge. And to quote Professor An, we have a long-term challenge, and we should not have a short-term solutions. That is the asymmetry of the governance. That should be something that we should avoid. Climate change is critical. If we have the asymmetrical governance, we do not have the resources, we do not have the means to tackle this huge challenge. If we really value and if we really think climate change is really important, the governance structure should be strong enough. And as a commissioner of the carbon neutrality, I feel that we should have a stronger governance to tackle climate change. In 2009, there was a summit meeting, and I have been visiting the COP every year. This year, and I attended the COP28 as well this year. As a regular attendee, yes, there have been some achievements like a Paris Agreement. More than 200 countries had a discussion and went through negotiation. However, things didn't get better enough. As managing partner Yoon pointed out, this is the 10th anniversary of the Sun Pro Bono Center. According to IPCC, internally within the IPCC, well, 1.5 degree scenario is almost gone. And many people are skeptical about 1.5 degree scenario within the IPCC. By 2040, we will go beyond 1.5, and after that, it's gonna go even higher, possibly 2.6, 3.2. We do not know. Even though we make our very best at the end of this century, probably we can make a U-turn to 1.5 degree at the end of this century. So that means the situation is really dire and serious. This is unprecedented. However, the intergovernmental relations, the intergovernmental solution is something we really need. However, as I told you, the outcome is below our expectation. This is a serious issue. The US and China have geopolitical issues. However, even under the conflict, they agreed on some agenda. One is climate change. They are going to have the cooperation on climate change. That's a good news. However, when you take a look at the news, actually, I have a little bit of the skepticism about it. We talked about scale up, speed up, and we have the Green Big Bang Summit. John Kerry, special advisor from the US, sent us the message about that summit. Of course, the key message is to triple the amount of the renewable energy sources just within 8 years. And we should ban any coal power generation, any new coal power generation. However, considering the situation in China and India, yes, they don't agree with the ban against the new coal power plants. Whenever we have the national level governance, we cannot handle this planetary governance issue. That is why we should focus more on the planetary governance system. Earth's jurisprudence, more than human. That is the right topic that we should tackle. We should have the Earth level governance. We should have the planetary level governance. Currently, it is only academic discussion, but that should be our reality. That should come into our daily lives. If we do not want to lose something precious, if we really want to tackle this issue, the planetary governance is something that we must have. After the 75 years of the launch of the UN, and I've been engaged in various task forces related to UN. But what I can tell you is this one: the global governance, the Earth's legal personality is something that we have been discussing for a long time. So I sincerely hope taking this opportunity under the topic of Earth's jurisprudence of more than human, we can contribute to have a solid discussion about the planetary governance. Our commission will pay attention to this conference, and we are going to consider how best we can contribute to better discussion about Earth's jurisprudence. And in the next year, I sincerely hope that we can have a joint discussion between the Commission and People for Earth. I sincerely hope we can have this kind of a collaborative discussion. This is beyond ideology. This is the matter of our destiny. This is the matter of our very existence. This is a really critical issue. Once again, thank you very much for hosting this wonderful and meaningful forum, and thank you very much. Thank you very much, Mr. Kim. And he delivered a really wonderful remarks, even though we gave him a short notice. Chairperson Kang will deliver the keynote so that we can open up this conference. I would like to invite Chairperson Kang of the People for Earth. Please welcome her with big hands.
I'd like to extend my warm welcome to all the distinguished guests who are joining us despite the cold weather. And we have also participants coming through the online channel. I'd like to extend my warm welcome to all the participants, Mr. Yoon and also Mr. Kim. They have shared wonderful congratulatory and opening remarks. And in these two remarks that we were able to learn the reasons why we are holding this conference. So my remarks are actually additional. One of the characteristics of this international conference is that the one law firm created the Sun, Pro Bono Sun, and also we supported the Academic Society on Earth Jurisprudence, which made possible for us to hold this international conference. So we're gathered here, various interdisciplinary scholars, and majority of them are specialized in law. So my keynote speech will be centered on law. While here standing at the podium, that I can see the majority of our participants and also the people, the core people in this group are legal professionals. As you know, the current legal system is elaborate and it has established foundation. It centers around human rights and rule of law. And this system is well reflected in the 1948, the Universal Declaration of Human Rights. And in the fight against fascism, the United Nations Universal Declaration of Human Rights were established in 1948. But as the two gentlemen mentioned in the remarks, that we are now facing geological epoch. From 2000s, that scientists have coined a geological epoch as the term, and then we've been using this term to describe the self-destructing symptom. So the human being started changing the environment, which is quite self-destructive. In the discussion of Anthropocene debate, we have to think about when the debate started, and one of the conservative views when it comes to Anthropocene discussion is it's known as that it started in the mid 20th century around the time of the successful nuclear test in 1945, and also antibiotics used for raising chickens. So against this backdrop, I think we culminated the Universal Declaration of Human Rights in 1948 based on this background. So, however, in this process that we have made clear flaw in our relationship with the earth. So the way that we have to go is going for generative energy and going away from the coal energy. And also we have to toward better science. In Korea, there is a common term known as climate tech. So we have to change the core law systems to reflect the new changes, and also we have to update the system to reflect our changes. So we are facing such difficulties. The reason is because also there is a tendency that the law accelerates the changes and the destruction of the environment. So in our law, that there are human rights law. So in this law, that the human rights and also the freedom of economy are secured, so that it has given so much discretion to corporations. So rather than upholding the individual human rights, that we are giving way more support to corporations, that we have achieved the economic growth, and on the dark side that we are facing the difficulties. So this is the right time that we have to think about the transition of our law system. And yesterday in Jeju Island, there were groups arguing for the protection of whales, dolphins. There are clearly gaps in our legal systems, so we have to think how we can interlink our current systems to achieve an environment where human beings and also the non-living beings can live together. The coordinator of UN Harmony with Nature program, Maria Sánchez, is unable to join us because of her father passed away. And then she delivered a congratulatory remarks yesterday. And then UN Harmony with Nature program has done a wonderful role in supporting the environment. And according to Maria, more than 40 countries are working to update their legal systems. And there are many revisions going on to update their legal systems. So 40, I mean, that's a wonderful number. Although in Jeju, that the one type of dolphin is specified in the discussion. However, there are many discussions going on and also legislation going on to include living beings beside humans to give rights. So in a broad perspective, the People for Earth upholds not only our relationship with the environment, but also we believe that we have to accordingly update our system. So I look forward to today that we will have wonderful discussions, interdisciplinary discussions. And Yuan mentioned that the Earth jurisprudence is not only limited to certain areas, but the 8 areas were designated, including policy, spiritual sector, and education. Our current system upholds human rights based on humanities. However, that now we have to encompass all the living beings on Earth. People for Earth has delved into many areas specialized in Earth jurisprudence. From diverse sectors of science that we have come to realization who human beings are, and also that we have realized our evolution process, then now we are standing at a stage how we're going to transcend that knowledge to our future generations, and also that we have delved into how we're going to circulate that knowledge with more people, and that's why we're going to hold a performance on the second day. Today, we are gathered to talk about Earth jurisprudence more than human. This is the time that we have to think about our law and also law governance system, and we need creativity because we need to make diverse approaches to meet in the middle. And I'd like to thank for the one law partners, especially for the Sun Pro Bono Center. And I'd like to thank the 2 gentlemen who made welcome and opening remarks, and also all the ladies and gentlemen who are joining us. I hope that today's conference will be a discussion session where we can seek the new future. Thank you.
네, 강금실 이사장님의 기조.
Thank you very much, Chairperson Kang, and she talked about the global climate crisis, and we should go beyond the human community, and the planetary system should be taken into consideration. Thank you very much. I'd like to thank Mr. Yoon, and also I'd like to thank Chairperson Kim Sang-yeop of the Carbon Neutrality Commission, and also I would like to thank Chairperson Kang Kumsil, who is the chair of the People for Earth. Thank you very much. Please give big hands to 3 of them once again. Now we're gonna move on to the session number 1, Earth Jurisprudence for the lawyers. The moderator will be Mr. Park Jun-woo, who is the attorney at the One Law Partners. Good morning. I am Park Jun-woo, and I'm working for the ESG Center for the One Law Partners, and I'm the moderator for this session number 1. When I take a look at the weather forecast, there will be the first snow in Seoul. So, to preserve this beautiful planet, I am the moderator for this wonderful session. Now let me introduce the topic for this session number 1. The session number 1 is Earth Jurisprudence for the lawyers. The Pro Bono Center, Sun, and People for Earth have been conducting the lecture on the Earth jurisprudence, and we can think about how we have developed the studies about the Earth jurisprudence, and based on the Earth jurisprudence, how we can develop the ESG activities and the legal litigations in South Korea. We have 4 speakers for today. The first session is Attorney Lee Yoo-jung, and she's been the director for the Pro Bono Center Sun, and her topic is the Earth's Jurisprudence lecture, how it has been conducted. She's been the expert for the gender-related laws, and she's been the expert for the ESG based on expertise. And she is now reading the human rights consultation for the Seoul City. And next, we have attorney Hyejin, and she's been working as a reporter for 15 years. She graduated from the Kangwon University, and she worked for the Suwon and the Seoul court, and she is now working as an attorney. She is the lead for the Earth Law Center, and she has been hosting our Earth Jurisprudence lecture. The third speaker is attorney Lee Young-ju. She's going to tell us about the ESG and triple bottom line, and she is a partner for the ESG Center of the One Law Partners. She is an expert in ESG topic. The carbon tax and the carbon trading is her area of expertise, and she is really active in governance. Last but not least, Professor Lee Jaehong from the Ewha Women's University will make a presentation about the climate litigation and Earth jurisprudence. Mr. Lee has been working for a long time for the Korean military services, and now starting from 2003, she's been teaching constitutional theories and the constitutional practices, and he is one of the best experts in constitutional studies. Now, following the agenda, I would like to invite Ms. Lee to the stage. Please welcome Ms. Lee. Good morning, I'm Jung. I'm working for the One Law Partners, and I am the director of the Pro Bono Center Sun. Let me tell you a little bit more about the Pro Bono Sun. And many of you know about the Pro Bono Center Sun, but probably some of you do not know about our Pro Bono Center. This has been established by the One Law Partners, and this was established in 2013. The Sun means doing something good to the society, and we serve to the society, and we enhance the society. That's why we call that as a Sun. And we have provided legal consultation, and you can see the list of the legal consultations about ecology and environment. For example, about the animal rights, and also for some of the cooperative and social ventures, and recycling labs, Greenpeace, and Ewha, and these are our partners. And we have provided legal consultations for these organizations. And these are some of the events we hosted focusing on ecological issues. Especially, we had lots of events in collaboration with the People for Earth. The topic is animal rights, the resource recycling, climate change, climate crisis. These are the key topics that we covered in our conferences. Pro Bono Sun had this kind of event. The One Law Partners is hosting the Earth Day campaign every year, and they are doing lots of activities to protect the Earth. And sometimes they give the gift and the award. So Pro Bono Sun and One Law Partners have been working on some of the voluntary activities, for example, like cleaning up the shore and cleaning up some of the waste. Today, I would like to tell you about the progress about the Earth Jurisprudence lecture. Starting from 2015, And up until this year, for the last 9 years, we have provided our jurisprudence lecture, and I would say this is the most important activities of the Pro Bono Son. And let me tell you how this was initiated. This can be a little bit personal. And Minister Kang was studying at the Catholic University, and she talked with some of the female attorneys, and she created a small study group. That was in the early 2013, and I was one of the small study group, and we studied about the ecofeminism, and we read the books The Spring of Silence, written by Rachel Carson. We studied about the planetary concept and ecological concept. That was really difficult to understand at the time, and how we can put that kind of difficult notion to the legal framework. I thought at the time it was impossible. Then Minister Kang told us that we should study this and put this kind of ecological concept into the legal framework. So we created a small organization, and People for Earth was started in 2015. And since then we have provided lectures on the Earth jurisprudence just like this. We have 4 topics in every year, and we provide lectures regarding Earth jurisprudence. You can see energy policy, animal law, animal rights, and the climate change. In 2017 and 2019, the fine dust, nuclear power generation, the rights of the animal, and Earth jurisprudence were the key topics. In 2018, the Earth jurisprudence came into being in earnest. In 2019 and 2020, we started to have discussion in depth about the Earth jurisprudence. We collected the cases about the Earth jurisprudence and how it was originated, and we discussed a lot about the Anthropocene starting from 2019. In 2021 and 2022, you can see some of the topics. We get fundamentally into human rights, ethics, sustainability. These are the keywords for our studies in 2021 and 2022. And we started to discuss how we can put that ecological and the Earth jurisprudence concept into our legal practice and legal actions. This is the topic for the Earth jurisprudence lecture, and we have introduced the decisions and the rulings from many other countries. And when we have the rulings from the court about the Earth jurisprudence, they can be a really good evidence for us to take a look at. And we can find some of the court rulings regarding Earth jurisprudence. We started as a conceptual study group, but now we are putting that concept into our practice. And we are studying about the human rights, planetary concept, and we are studying a lot about the Earth jurisprudence, how we can put the Earth jurisprudence into our litigation, and when we are making the law, and when we are discussing and making a process about the legal activities. Initially, we had only 30 to 40 participants. However, in 2023, 240 people applied, and we had 4 lectures in average per lecture. We have around 150 participants. We have more and more people coming in as we had online lecture, and I believe actually the audience was much bigger than 150. This is pro bono activities. Not just the lawyers, students, teachers, and many other people are joining these lectures because these lectures are provided for free. And I can say there are growing interest about the Earth jurisprudence right now. Then what can be the meaning and implication of the Earth jurisprudence? I know that many people will talk more about the Earth jurisprudence. Earth jurisprudence is based on the concept human belongs to a bigger community, and the well-being of the each and every community member is really important. So I would say Earth's jurisprudence is like a philosophy about the legal approach, and this is about the governance. And thanks to a book which was published in 2016, we started to have the discussion about the Earth's jurisprudence. And after that, we started the lecture on the Earth's jurisprudence. And that's a really remarkable achievement. Pro Bono Sun and the People for Earth have been working really hard for these lectures, and I feel so proud about these achievements we made, and I am so proud that I am the member of this community. The legal system is based on the human-centered approach. This one is based on the nation's power or the nation's authority. This is human-centered again. This has lots of the limitation when we are handling ecological issues. There is no room for non-human beings, non-human creatures. And ecological damage is calculated based on economic terms. That's an issue. The damage is calculated based on the ecological terms. So non-human creatures' damage cannot be calculated and cannot be measured within the existing legal framework. It is really obscure. To whom should we ask for the responsibility? It can be nation actor, it can be a group, it can be something else. Then how about the rights of the non-human creatures? Then how about the rights for the community? Then how about the rights of the nature? That have been ignored, and that was really almost impossible to be protected in the existing legal framework. That is why we had a lecture on the Earth's jurisprudence. We underlined the importance to the shift to climate transition and ecological civilization. And we had a multidisciplinary approach from the philosophy, ethical studies, science, economics, and the politics. We have introduced the rulings from international courts. So we studied a lot about the implications about the Earth's jurisprudence. We also had some discussion to build the expert group about animal rights, social venture, and climate technology. And we had a great discussion with the companies which can think more about ESG management. In 2020, the Youth Climate Litigation was launched in 2020. Not just Pro Bono Sun and other groups were working together. The young people made an appeal against the national government. It is going against the constitution when the national government abolished its carbon reduction goal because it is damaging the rights about the young people. They want to live in the clean future and they want to lead the healthy lives. However, when the government is abandoning their carbon reduction policy, it can damage the future rights of the young people. And this one is pending in the Constitutional Court. In 2021, in the federal government of the Germany, there was a really wonderful ruling that was made. And there is a climate change act from the Germany, and they had the carbon reduction goal, and there is a annual reduction target. However, the Constitutional Court ruled that goal is not good enough. And to make the carbon neutral society, the goal should be more ambitious. The ruling was made by the German Federal Court. The government should protect the future generation, otherwise it can be the infringement of the fundamental human rights. And I believe this ruling will have some implication to the constitutional ruling that's going to be made in South Korea. Also, we supported the activities of the young people. A Korean large company talked about the green management. However, they supported new coal power plant. And the young activists said this is going against their company campaign. They drew some paintings on the logo of the company and they were sued by the company. And the court rejected this kind of litigation that has been initiated by the company, and the young activists were fined for painting on the logo about the company. However, they are going against the ruling and they are making some protest activities. And constitutional appeal was made about climate disclosure that was initiated by Greenpeace. Sustainability and sustainable development is really important, and to make it happen, companies should disclose their sustainable activities and their ESG activities. That is a mandate. That is climate disclosure. However, the Korean government were really passive about this climate disclosure, so another constitutional appeal was raised. However, this one was rejected. However, I believe this was really meaningful appeal. And there were many litigations related to climate change. We can find out some of the legal issues related to climate change, and we can potentially change the perception of the stakeholders and the general citizens. And possibly that kind of appeal can have some implications to legislation and court rulings. This kind of positive cycle can be made. So I would say the litigations we made can be really meaningful. And the court ruling is really important because that is a binding decision. Now let me tell you a little bit more about the feminist jurisprudence. This is my major area. I majored in the feminist jurisprudence in 2010s. In 2010, many people do not know about the concept of gender in Korea. The voting rights for female was given only in 1890. It's just about 150 years ago. The female rights was recognized in just about 100 years ago in the US. We didn't talk about the rights for the female for a long time. However, the achievement was really significant. Still, there are many women and girls who risk their life just to go to school. Still, the feminist jurisprudence are now focusing on their concept and how they can put the feminist concept into legislation and legal process. And another key area is how to represent the marginalized female on the legal discussion. And that is why litigations should be made. And there can be some active, and after that, some of the achievement can be made. As you can see, for example, some rules were changed, some policy were changed because of the litigation raised by the feminist jurisprudence. Just about 20 years ago, not many people know about this concept. However, thanks to the activists from the feminist jurisprudence, many things have changed. And this kind of approach can be something that we can learn from the Earth jurisprudence. That's why we should make more litigations. Earth jurisprudence is asking for the fundamental shift in the legal system. There are lots of scientific development, including AI, and now we are going through the fundamental changes in climate, and science and society. That is why we need fundamental change in the legal system. The Earth's jurisprudence should pay more attention to non-human creatures that have been marginalized in the existing legal system. We should think more how we should build a new legal system. And I'm pinning high expectation how Earth's jurisprudence can contribute for the future legal system transformation. I would like to thank all those members who are working for this transformation. I would like to thank all the members of the People for Earth and all the members of the Pro Bono Center Sun. Thank you very much.
네, 수고해주신 이유정.
Once again, please give a big round of applause to Lawyer Lee. Thank you very much for your presentation, and especially, yeah, it's remarkable that there are hundreds of people are now joining our study on jurisprudence, which is a great indication of increasing interest in Earth jurisprudence. I asked her to manage her time in 20 minutes, and then she managed the time. And now I'd like to welcome the next speaker, Ms. Hyejin Jung. Nice to meet you. I am in charge of Earth Center at the People for Earth. I was in charge of the administration work, but now actually I'm promoted to the center head, but actually my role is not that big. Today I'd like to talk about how the Earth prudence has been developed in Korea. While operating our academic, there have been many things that we were able to learn through our discussions. So we have been able to think about how we have to continue to develop our discussions. So these are the contents of our discussions today, that I'm going to talk about the birth and the development of Earth jurisprudence, germination of Earth jurisprudence discussion in South Korea, and I'll also share the achievements of our academic and network so far. I'm sure that you're familiar with this concept. The Earth jurisprudence was envisioned by Professor Thomas Berry. In 2001, that he said the Earth needs a new jurisprudence. He wrote a short essay about the origins of rights. And then that was the beginning of the term Earth jurisprudence started being used popularly. And the lawyer, Kumsil from South Africa, he happened to learn from Professor Thomas Berry, and he was working as a lawyer in South Africa. And while listening to the lecture by Thomas Berry, he had a chance to widen his understanding. And then he was greatly influenced by Thomas Berry, and he wrote White Law. The legal practice, the person put the knowledge of Earth prudence first time as Wild Law. So the first version was published in 2002, and the revision was published again, and also it greatly influenced the Ecuador's constitution. And with this development, UN started dealing with nature rights, kicking off the organization UN Harmony with Nature in 2009. So the term was coined in 2001, and while going through the development in 2000s, the concept has been now flourished. And now I'd like to talk about how the discussions in Korea has been developed. And when it comes to the jurisprudence in Korea, that we must talk about Madam Kang. In 2015, that we started a small organization, actually a small group of people, with the Minister Kang and the lawyers gathered together, and Professor Park Tae-yeon. We started reading the book White Law, written by Mr. Cullinan, and then we launched the group People for Earth, and also we created a lecture course to learn about the teaching of Thomas Berry in 2016. Starting from 2015, that we started studying white law, and in 2016 we published a translated version. I don't know if you can see this. The title is the White Law, and the subtitle is a manifesto for Earth jurisprudence, and this is the first translated version of Earth jurisprudence. And since then, we've been studying related books, and then one of that is the ecology of law. So a physicist and the law professor had discussions on the ecology. You might think that there are great distances between the physicist and the law professor, but they discussed that there should be wider discussion, and we also published a translated version. So while translating these two major books, we came to the point that we'd like to summarize all the knowledge that we had accumulated. That was the point that the theory was not enough, developed enough. However, that our knowledge was good enough to invite general audiences to be better acquainted with the concept of Earth jurisprudence. So the people who were in our group, we started writing each one chapter by one person. So our book, 지구를 위한 법학 in Korean, or Earth Jurisprudence in English, was the first one in Korea. So the subtitle is the Earth's Century, Going Beyond Human Centrism. The English title is Earth Jurisprudence. However, in Korean, in direct translation, will be the Jurisprudence for the Earth. So there are three major chapters. The first part is explaining about the Earth jurisprudence. So the three chapters are dedicated to the introduction. And the second chapter is about the changes of Earth law and international society. In the second chapter, that we discuss about the Earth jurisprudence and the role of UN and international civil society. And also in the third and the last chapter, that we dealt with the Constitution and Earth jurisprudence. The reason is because and also another one was economics. The reason is because the writers who were in charge of the third chapter majored in constitutions and the economy. To publish the book, that we held 10 times of seminars, and before that we had shared our opinions because we read the previous two books together. So we did our best to help the Korean audiences to have interest in Earth's jurisprudence. And I'm sure that you also have received this book. While I was preparing for this presentation, that I didn't know that this book would be complete by this time. The publisher name is 문학과 지성사, and we decided to publish one book every year. As you can see, that we are talking about biocracy and the situations in Korea, which has great relevance to the theme that we're talking about today. So this is more about the theses, more about academical perspective. So now I'd like to talk about the Google Scholar. So if you look up Earth jurisprudence, that you see different titles, the human rights and Earth jurisprudence, going beyond human, that's the first title. And these are the papers published by the people who are studying in our group. And the number of the papers have grown to over 30, 40. And also, Lawyer Lee introduced our study. Starting from 2019, that we have been conducting this class 4 or 5 times a year. Initially, we talked about environmental law, but mostly that we come up with the topics that grab the public attention, and it's been 5 years. So our approach is that we set the subject as Earth jurisprudence, but the topics are decided based on the subject that have great public's interest. And as Lawyer Lee mentioned, the attendance for this class have exceeded hundreds. I share the academic efforts of People for Earth, and now I'd like to talk about how we are expanding our network. This conference is hosted with the UN Harmony with Nature. As I mentioned briefly, UN launched this program in 2009, and their role is basically celebrating the Earth Day on April 22nd, and they hold various dialogues by inviting speakers from different sectors. And at the end of the year, they publish annual reports, including the dialogue, which take place near the Earth Day. And People for Earth was included in 2019-2020 report introducing Korean situation. As Madam Kang mentioned, that About 40 countries around the world are now upholding the environmental rights by upgrading their constitutions and also by providing education to students. So while working closely with Harmony with Nature, that we have expanded our network with bigger audiences around the world. And in relations to the Earth jurisprudence, that we're also making diverse efforts. So the first book on the left is Silent Crime, Ecocide. This book is about ecocide and the human rights. Since Earth jurisprudence is actively flourishing in Latin America, that we also held a conference with the topic of Latin America. And as you can see on the right side, various experts from the world, from different sectors, are joining together to have discussions. And as Minister Kang mentioned, that in Jeju Island, the ecological cooperation has been actively discussed to protect dolphins. And in this process, our discussion made at the People for Earth are reflected. So these are major achievements. Previously, I showed you how many papers are looked up in Google Scholar in Korean, but here I'd like to show you how many papers are published with the theme of Earth jurisprudence. But as you can see, the number is great, which is quite different from Korean situation, because in Korea the discussion is at an infant stage. So we have built some cases, so we have to continue to contribute to the development of Earth jurisprudence. Currently, that we have only a few researchers who are dedicated to Earth jurisprudence. We have published translated books. We read the books together. However, only one professor is responsible for these book reading process. And since we have limited number of researchers dedicated to Earth jurisprudence, that our discussion is more about learning about the concept of Earth jurisprudence and what kind of researches are going on around the world. So now we have to grow to find ways how we can apply this concept into Korean situation. We are in the process of discussing. We don't have yet established discussions. So through active discussion that we have to make foundation so that we can create a legislative and successful litigation case based on Korean-style jurisprudence system. With these points keeping in mind, that we'd like to have active discussions in the international conference, and I'd like to wrap up my presentation. Thank you. Ms. Chung, Center Head of the Academic Society on Earth Jurisprudence, thank you so much. So through her presentation, that we were able to learn how Earth jurisprudence was born and what achievement that the Academic Society has achieved and the directions that we have to go toward. The Academic Society on Earth Jurisprudence started as a small book club, but now that they are a matured group that published their own book, and also they are holding this international conference. And also she said that there are limitations, obstacles. There are very limited researcher pool in Korea. So I hope that the more people can show their interest in jurisprudence. Thank you.
Third, we have our attorney Young-Ju Lee. Please welcome her with big hands. Good morning. I'm Lee Young-Ju, who is working for the One Law Partners, and I'm working for the ESG Center located in One Law Partners. So this is the meaningful occasion, that 10th anniversary of the Pro Bono Sun. Thank you very much for giving me this opportunity. Two wonderful speakers made a wonderful remarks. I sometimes listen to the jurisprudence lectures, and I've been engaged in lots of activities, and I'm wondering myself whether I am on the right tide and I am following the topic or not. But listening to the presentations, I can now understand where I stand and where I was, and what was the trend about the discussion about the jurisprudence in South Korea. That was really meaningful for me. The topic is the jurisprudence, ESG, and triple bottom line. Jurisprudence is a philosophical transformation, but ESG is a very realistic concept. It's more like a capitalistic concept rather than the philosophical concept. It can be a kind of paradox, but what kind of message can I deliver? And I was talking to myself. And ESG is covering the very wide area of the business activities. So I wanted to find out how best I can explain and what can be the common factors between the ESG and jurisprudence. So I would like to tell you about the basic concept about the ESG, and especially focusing on the E, environmental factors out of ESG. And that is something that I want to do today. As you can see here, many people talk about ESG, and now many people ask me about ESG because in the last 2 to 3 years, people's awareness about ESG has gone up significantly. Many people do know about the concept about ESG itself. As you can see, this is the acronym for the environmental social governance. In a nutshell, we can call that sustainable goal. In the Basic Act for the Sustainable Law, it is defining do not sacrifice the needs of the current generation in order to meet the needs of the future generation. Rather, we should work to achieve the harmony and balance without wasting the resources or deteriorating the conditions of the economy, society, and environment. And I've been working with many of the other organizations to deliver lecture about ESG. Many people ask me, how can you define ESG in a single word? Let me put it this way. Let's say you make an investment to an organization or to a company. You make investment, be it $100 or $1,000. In the past, you get the information financially this company was solid or not. How was their sales performance? Are they good on credit or not? You can get that kind of financial statement or the balance sheet. Those information is provided to you, and based on that financial information, you make a decision whether the company is really good or not. However, now in the era of ESG, now we can have another piece of information in addition to the financial statement. For the last 5 to 10 years, yes, there are financial information and there is a prediction for the next 5 to 10 years, the financially. But in addition to it, when it comes to environment and the human rights, the company is likely to get into some kind of trouble or not. That is something that we should know. So there should be another KPI for the company. So ESG can be another indicator for the prediction about the value of the company. So I would say ESG is a non-financial indicator. However, it's really critical. The US and the EU have been initiating the concept about ESG activities. Regarding ESG, the key topic is information disclosure. We call that as a environmental disclosure. A company should disclose enough information about its ecological and environmental activities. That is a key topic in the US and the EU. The capital market is mandating a company to disclose a certain set of information. That's really important, and there is a heated debate about it. If we want to make some fundamental changes about the behavior, the disclosure mandate should be changed. And sometimes people are questioning, do you really think that changing the disclosure mandate will change the behavior of a company? Yes, partially. Because when you are giving the mandate for the disclosure, sometimes it can fundamentally change the behavior or the corporate activities of a certain company. You can see the TCFD disclosure. This is a kind of the de facto standard for environmental disclosure. You can see governance, strategy, risk management, and metrics and the targets. Based on this, the TCFD is mandating the company to disclose information about environmental risk. And also you can check whether the board members clearly understand the environmental risk or they are taking some environmental actions. You can ask those questions, and based on your questions, the board should come up with this kind of disclosure. TCFD is a really important indicator. For example, in the US, in the EU, and even in the IFRS, TCFD has been considered for a long time. In Korea, actually this has not been mandated yet. However, KRX and the ESG are now trying to refer to TCFD for the future mandate. Now let me tell you about the key changes about the environmental disclosure. You heard about IFRS. IFRS is a standard-making organization about the global accountings and the disclosure. They have IFRS S2 climate-related disclosure. This has been mandated starting from this June. When Korean companies are trying to come up with the K gap for the financial statement, which is a little bit different from the IFRS, and we have the Korean gap. But when you are creating the financial statement based on the K gap, internationally, it is a rule to follow the rules mandated by IFRS. Now IFRS is asking for the S2 climate-related disclosure. So IFRS already published this kind of rule, and that will have a huge implication across the world. IFRS S2 talks about the carbon reduction and carbon emission. And there is a scope 1, 2, and 3. Scope 1 and 2 are related directly or indirectly to the company. And scope 3, the S3, is covering the entire life cycle, including their partners and the supply chain. So I would say when they have the S1, 2, and 3, in that case, it's going to cover the climate change and the carbon emission track record across the company's activities. S1 is the general request, and S2 is the mandate related to climate change. And EU, they came up with the ESRS in July. So in Europe, in a nutshell, climate change, ecological impact, the resource usage, and the recycling, those 5 factors will be mandated so that the companies should disclose the information about the key 5 sectors. Along with the public disclosure, they should explain how those environmental activities will have impact to their financial gains. In the US, the SEC came up with the guideline in March, and they are going to confirm the guideline. According to SEC guideline, in the regular disclosure, companies will be mandated how their climate actions will have impact on their revenue and financial statement. So far, I've been telling you about the international trends. Of course, the timing will be different country by country. However, we can see the general trend. We still do not know how much impact there will be, but the trend is very clear. ISSB, US, EU, and those advanced countries are taking action so that the companies can clearly measure their environmental impact, and there has been lots of discussion on it, and there will be potential mandates to disclose their information related to their climate activities. So far, I've been telling you about the international activities, how the companies should come up with the information and how they should analyze the information and what kind of climate activities have been done. That kind of mandate will come into place. In the last September, there was another important step made. Beyond the climate impact to the corporate activities, TNFD initiative, which is covering the biodiversity, was now officially launched. TNFD is asking for the disclosure about natural resources. In the last September, they came up with a recommendation. The recommendation from the TNFD will be discussed in many other countries. The recommendation from the TNFD is not just talking about the climate change, it is talking about the natural resources as a whole. How the company activity will have an impact on the natural resources. What is the plan and what is the strategy? This is more like a planetary approach, and that recommendation was made in September. TCFD, as I told you, is now talking about the transitional risk and the physical risk coming out of the climate changes. When companies are making a transition, there must be some risks involved. That's the transitional risk. TCFD is talking about the climate change related physical risk and the transitional risk, and the TNFD is talking about the transitional risk about the natural resources itself. TCFD has discussion for the last few years, and then they finally had a contribution to IFRS. And after a few years of the discussion within the TNFD, and TNFD will contribute to some of the international mandate. Companies not only have to take care of the climate change, and they have the risk management and governance about the biodiversity. Probably they have to put that kind of information in their financial disclosure. TNFD talks about natural resources, and this can be related to Earth's jurisprudence. However, we need to have a further discussion and further study what can be the linkage between the TNFD's natural resources and the Earth's jurisprudence. Finally, we can find out some kind of alignment between the two sectors. So far, I've been telling you about the international trend. Now, let me get back to some of the domestic issues. Many efforts are being made within the country. Of course, not something tangible has not been made, but the Ministry of the Environment, the Commission for the Fair Trade, and the Commission for Financial Services are now discussing how we can put those rules into our practice. The Ministry of Environment is now trying to put a kind of the mandate so that companies can disclose their climate-related activities. However, there has been lots of criticism. Company level information cannot be fully disclosed. However, the Ministry of Environment is trying to follow the global standard and probably they will come up with better recommendation. I can tell you the Ministry of Environment in South Korea is now actively listening to the international trend. ESG can be a bottleneck for the company's activities. However, this can be opportunity at the same time. Many people talk about the basic legal framework for the ESG. This has been launched by the National Assembly in September this year. ESG should cover environmental human rights, and when companies are revealing the information, they should reveal and disclose meaningful information that can be verifiable and measurable. The National Assembly is now trying to come up with who should be responsible and what is the content and what is the standard and how it can be verified. So they are trying to build an ecosystem where ESG can be fully represented in the company information and that can be fully measured and analyzed. And there is a Capital Market Act. Article 159 is the right clause related to company disclosure. I told you there was a constitutional appeal that was rejected. This is the Article 159 from the item 1 to 5. And what are the key items that should be disclosed by the company? However, even though climate disclosure is really important, the Article 159 is not covering any item relevant to climate change and ecological activities. So many people are arguing that some items should be added relevant to ecological activities or the climate change. And there are some recommendations. For example, the Article 159 can be changed like this. For example, any activities related to environment, sociology, and the governance. And there is another recommendation presented by the lawmakers in South Korea, and we are now discussing how we can modify the Article 159. And also, there is a discussion that we can come up with a modification of the 159 and the details can be defined by the presidential decree. And there is another recommendation. For example, focusing more on the climate change, this can be the potential modification. Greenhouse gas emission reduction goal, climate change response plan should be within the company disclosure. If this recommendation is accepted, in that case, anybody can have access to this kind of climate-related information. And within the financial statement, you can see greenhouse gas emission reduction goal and climate change responses. Currently, we do not have this kind of information in the financial statement, but once we have these information, this will have significant implications across South Korea. When you take a look at the item 5 and 6, there is a term, the environmental strategy. And when environmental strategy is included within this item number 5, the board should explain what kind of climate responses they are taking, and they should explain that to shareholders. That's going to be a mandate. However, even though we have heated debate, the FSC, the Financial Services Commission, understand ESG should come into place. However, they delayed the plan for the implementation. We had the third round of the discussion. Probably the disclosure will be made after 2026, which means in Korea, yes, the disclosure may be a little bit delayed compared to other countries. This one is coming from the Fair Trade Commission. Greenwashing can be an issue. So to prevent greenwashing, the Fair Trade Commission is coming on with action. You should not deliver any misleading information about the greenwashing, and Fair Trade Commission came up with this kind of guideline in the September. And when you are using if this one is green or the eco-friendly, the company should be cautious about using those terminologies not to mislead any consumers when they are using the word like green or eco-friendly. I covered the international trends and domestic activities about the company's disclosure mandate. The link between ESG and our jurisprudence might be very small. However, as there is a international transformation and international shift about the ESG and our jurisprudence, I can say the corporate citizens can now focus more on the climate responses and biodiversities. And when they have the mandate about those areas, that can be really meaningful. And that is why I'm telling you ESG can be linked with the Earth jurisprudence because the companies can be the member of this Earth community. That's it from me. Thank you very much. Please give big hands. Thank you. Ms. Lee, thank you very much. She talked about the basic concept about the ESG and the disclosure within Korea and outside of Korea. And thank you very much for the wonderful insights.
이재용 교수님의 발제 듣도록
Now I'd like to welcome Professor Lee Jaehong. He is the last presenter of the first session.
네, 네 번째
My name is Lee Jaehong. It gives me a great pleasure to present my presentation to you on this wonderful occasion. Today, I'd like to talk about the climate litigation and earth law, Earth jurisprudence. We are given only 20 minutes, so but my topic is very heavy, so I don't think I can cover everything here, but I'd like to today focus on the constitutional petition for the carbon neutrality basic law. I prepare this picture. I don't know if you're familiar with this photo, that there is a hint. If you look at the right corner, there you see this flag. And this is the Federal Constitutional Court in Germany. Korean Constitutional Court and also the German counterparts, that they meet every 2 years. And last year we had the representatives from the Constitutional Court from Germany. And then one of the 3 topics was the climate litigation. So they share the results, and then they emphasized that one of the judges emphasized that we stick to the existing verdict. But if you look at the letter of the judge, the ruling, that the verdict, the content itself was quite creative. However, he emphasized again and again that he stick to the existing constitution, because it is important that we can't go too far from the legal jurisprudence. And of course, it's nice that we can tell or appeal to the judges that this is a really good point, that we have to embrace environment. However, that the judges, they have to stick to their existing legal framework. So we have to remember that. So now I'd like to look at the target of the constitutional appeal of the carbon neutrality basic. So here, the subject of the article, which is Art 7, is about the. There are two parts. There are targets set by the government about mitigating the CO2 by 2030. However, there is lack of reduction target from 2031 to 2050. First of all, I'd like to talk about the first one, about the reduction of CO2 by 2030. And for this issue, I'd like to talk about the three types of state intervention in fundamental rights. You see that the thick line is the area of basic right protection, and there are three concepts: prohibition, formation, and protection. So the limitation and protection are major areas to consider here in terms of human rights. These are the articles related to the environmental law. And I'd like to talk about the limitations, especially the environmental rights limitations. These are the one of the representing cases. The first one is setting up the safety bar in the prison. When we think about the prison, then safety bars are placed in the prison already. However, the prisoners are complaining that the safety bars are too narrow, so it's difficult to enjoy the light or ventilation and heating. So if we compare before and after, that you can see that the freedom or the basic human rights are infringed. And in this case, there is a prohibition of excessive restriction. And also, in terms of the environmental law, that I'd like to talk about the emission reduction target by 2030. So this can be gone with the same article, which is Article 35, Paragraph 1. The reason I divide the limitation and protection is based on two important legal frameworks. If it is the limitation of basic right, then it is subject to the provision of excessive restriction. However, if it's too much protected, then the prohibition of deficient protection should be applied. For the question number 1, for the 2030 reduction target, we have to think it's whether the basic human rights are limited or not. And subject number 2 is the legislative absence or inefficiency. To look at this, that we need to know the concept, whether this matter is subject to the true legislative inaction or defective legislation inaction. One of the cases is the noise and this is a real case. And then this one was appealed by a study room owner. He opened his business, and then he complained that there is water flowing sound on the ceiling. And then he looked up the related laws. However, he realized that these noise all indicated in the law are about the exterior noise. And he appealed to the Constitution and he complained why there is no noise standard generated by the building itself. And the argument too is why did the noise standard doesn't include various circumstances. So the first case is genuine legislative oversight, and the second argument is lack of legislation. This is also the same with the environmental law. For the CO2 reduction by 2030, there can be two arguments why CO2 reduction target is made until 2030, but there are no targets after 2030. The reason I'm asking you is because there is no right or wrong answer. And if you look at this picture, that there is a vase in the middle. However, if you see in a different angle, that you see two faces facing together. So there is no right answer in this appealing case. However, if you say that there is a one answer, then there will be a lot of arguments will be made. And this one is the study room case. The judges had two different opinions, 6-4. For example, that they argue if we consider from the picture that I showed, 6 people said this is the vase and the 4 people said this is the vase. So we can, for the first case of the study room, then we have to think about the constitutional, if there is a constitutional legislative mandate or if there is a legislative duty to interpret the Constitution. And in the in-text citation, then there are difficulties in interpretation. First one, in the case of genuine legislative inaction, in this case, legislative rejection or substantial lapse of time should be considered. However, in the second part, sluggish legislation, the prohibition of deficient protection should be applied. However, there are rare cases where the country would do the least minimum appropriate and efficient measures. So whether it's the subject number 1 or 2, there were difficulties in this case. And also by learning these two cases, then we can apply this to the Earth's jurisprudence. In the book of The Idea of Justice, there is a term called the plurality of fair reasons. So in these difficult discussions, that the discussants can come up with the only way or only answer. And he used an example of the Buddhist teaching, Amartya Sen. So here, what they argue is that the cooperation for mutual benefit between equal actors can be achieved through various sources, and especially in the relationship between parents and the children, there are different responsibility. For example, if children are in danger, that the parents have higher responsibility. And one of the related arguments can be made, can be referred from Hans Jonas. And he said that I'm responsible for resolving situations that are within my power, even if I didn't cause them. So by reading this book, that we can learn that even though the leader earned a coup, he has to use his power for his people. So if we look at this in a perspective of time, that we can consider the present decision, which can affect to the future decisions. So if we combine the generations, then we can make the logic current generations and the future generations. So if I summarize everything what I said in one sentence, with great power, there must also come great responsibility. Do you know who said that? Actually, this is not from Hans Johansson. This came from Spider-Man. Spider-Man said that, so even 5 or 6-year-old know the concept, with great power comes great responsibility. So the theory came from Hans Jonas. It's not only their responsibility, but ethical responsibility. So what I'm trying to say is, if you use ethical responsibility as a tool to appeal to judge, then the judges would not hear you. So our role is now taking the ethical messages and interpret that into legal constitutions, legal frameworks. There are existing basic rights, which is that our right to live in a stable and climate. So that is indicated in Article 35, Paragraph 1. However, if we apply this to the nature or to the future generations, and then if we say that if the country has the constitutional responsibility to protect the future generations, then the decision can be a little bit tricky. And this should be interpreted as the care and the responsibility. So when we approach the Constitution, we have to approach it with the concept of care, because the Constitution also mandates the obligations to protect the children, fetuses, and posterity, and life in this life in the stable climate of nature. So these are the important articles that we have to refer to. So if we go to the court case, then the scale and the intensity of judgment should be considered. So if we choose true legislative inaction, then the standard of the judgment or the ruling should be whether it is protected too much, or there is deficiency of protection. And in terms of deficiency of protection, also we have to think about how much is deficient. Since we have in the position of winning the case, that we will argue for intensity of scrutiny. We will argue for the intensifying the scrutiny. In terms of increasing the level of scrutiny, that we can argue with 4 theories. The basis can be, we can argue that there are a number of 4 cases. The more severe the restriction, the less socially relevant the realization of the right. That is number 1. And number 2 is the less predictive judgment required by the legislator. The more specialized the judiciary is. And also, there are 4 the level of scrutiny. However, for the climate change litigation, it's difficult to argue for the heightened scrutiny related to number 2 and number 3. So we'd like to focus on 4, which is that care and consideration. So the judiciary is specialized in the area of protecting minorities and disadvantages, and the legislation doesn't necessarily protect the marginalized people. However, the Constitution is at the standing at the point where they have to protect the minorities and disadvantages. So this Constitution should be able to protect the marginalized people. And in that context, we can argue that the Earth jurisprudence is part of such care and protection. And the existing case argues that the higher the natural connection to the realization of the right, the more intense the review should be. So in this case, that we can argue that the humans alone cannot realize environmental rights without climate environment. So I'd like to now wrap up my presentation. We're not here arguing, we're not writing an essay here. We are basically appealing to the Constitutional Court. So we need to appeal. We need to argue based on the legal jurisprudence, the existing jurisprudence. So we need to exactly what point that we have to argue. And we are standing at a position where we have to go beyond the existing constitutional jurisprudence. So again, that we have to translate our language to the jurisprudence language. So in this regard, we have to argue that the caring and compassion are constitutional duty. So we can increase the possibility of winning in terms of increased scrutiny for care and consideration cases. So it will be a good approach for us to find a possibility for winning the constitutional case. Thank you. Please give a big round of applause to Professor Lee. And it was a difficult constitutional presentation. However, he was able to put it into perspective so that we can learn about the Constitution. So we have come to the end of the first session. After the first session, that we're going to have lunch, and we'll be back with the chapter 2. Thank you.
네, 안녕하세요.
Good afternoon. Now it is time to get started with the session number 2. In the morning, we had heated debate, and the talk was really wonderful. And regarding the Earth's jurisprudence, we heard a lot of the insights. In the afternoon, we're gonna listen to more how we can handle this climate crisis, what kind of governance system should be developed. And we have renowned scholar, and 2 scholars will make a presentation, and then we're gonna have a discussion. The first presenter is Dr. Louis Kutse, and for the Research Institute of the Hamburg, he is a research fellow, and it's more like a think tank. And yesterday, he and I had some conversation, and that is the organization studying the sustainability from the multidisciplinary approach. And he is a research fellow at the Hamburg institution. He is originally from South Africa, and he is the professor for the Northwest University, and also he's working for the Lincoln University of the UK. And for the ecological constitution, and in the morning, yes, we had some discussion about the ecological constitution, and also regarding the Earth governance, he has lots of studies about the ecological constitution and Earth governance. Now the floor is yours. Please welcome him with big hands.
Thank you very much for this very warm welcome. So, dear dignitaries, colleagues, guests, I'm really deeply honored to be here today with you, and my deep appreciation certainly, especially to Minister Kang and her colleagues for the very warm invitation and the extremely generous hosting that we enjoy here. I am absolutely delighted to be with you and to join in this important discussion about Earth jurisprudence and the planetary vision of environmental protection that we are having over the course of these 2 days. I firmly believe that despite all of these crises that we facing from war, hunger, oppression, and so forth, the planetary crisis certainly is now the most urgent one to consider. And as Minister Kang had so eloquently said also in her keynote this morning, humans have become a very, very powerful geological planetary agents. And we have entered the Anthropocene, which is characterized possibly by irreversible impacts on planetary integrity, increasing zoonotic diseases, as we see with COVID, for example, intensified differentially distributed vulnerabilities that characterize a deeply uneven world order, and of course the rise of geopolitical conflicts as we see. And this is the crisis of the Anthropocene. Alarming climatic, ecological, and certainly also public health trends, which are all unfolding with very little evidence of abating. And the convergence of all of these trends could lead to a comprehensive crisis where multiple risks materialize in reinforcing ways. Now, Joshua Gellers argues that the pronouncement of a new geological epoch has created the discursive space that we urgently need to critically re-examine the role of law and governance, and imagining in a creative way, an innovative way, a daring way perhaps, how it might be reconceived to address the complex problems caused by industrialization on the scale of the entire Earth system, as we've also heard this morning. And today I want to disentangle and critique the role of law in creating the Anthropocene's crisis, as well as law's inability, thus far, up until now, at least, to effectively address this crisis or to offer solutions that can meaningfully craft a sustainable and just future, not only for humans, but also for non-humans. And I want to focus specifically on the area of international environmental law. We also look ahead and ask how international environmental law can be reformed to initiate a very long overdue global governance paradigm shift that can confront the deepening Anthropocene crisis. Now, the argument unfolds in several parts. Part one interrogates some of the key features of and failures of international environmental law. And the discussion specifically focuses on three themes. First, the inability of international environmental law to embrace an Earth system perspective and to respond to interconnected Earth system governance challenges, a matter that my colleague, Professor Kim, will speak about immediately afterwards as well. Second, the anthropocentrism of international environmental law that renders it unable to care for particularly vulnerable human beings and, perhaps even more importantly, and the focus of our discussion over these 2 days, a very vulnerable non-human world. Certainly also to the extent that this anthropocentrism counterproductively facilitates environmental destructive neoliberal economic development. And this, of course, is also where corporations come in, which we've already heard about this morning, and we will hear a little bit more about during the course of this talk. And certainly also international environmental law's lack of ambition at a time when precisely such ambition is urgently required. Now, the limitations of international environmental law. I think it's fair to say that international environmental law has made many important contributions to environmental protection in the Holocene epoch. Yet, despite many of these positive developments, it needs to be recognized that there are very clear constraints on what international environmental law can do and can be expected to do as it develops further. If international environmental law is to do more, it must move beyond the constraints of its current architecture and its framing, and it must embrace a fundamental reconceptualization of existing models of governance, whether economic, political, social, or legal. And the new context of the Anthropocene reveals the limits, I think, of international environmental law. Among others, the existing set of international environmental law rules have all been created based on our collective human experience and understanding of a relatively stable and predictable Holocene epoch, the epoch just before the Anthropocene. So international environmental law has therefore not evolved in step with the continuously changing conditions that characterize the Anthropocene crisis. In other words, while the context in which international environmental law was conceived and operates has changed, international environmental law itself has not changed in tandem with that context. We sort of remain on a mission to save the planet, one small little piece of environmental law or treaty at a time. But this is not enough, because the challenges that international environmental law now needs to tackle have become both incredibly complex and enormously challenging. So in what follows, I reflect on three limitations that are preventing, I think, a meaningful progression to a form of international environmental law that can govern powerful human beings in the Anthropocene. And first, we will look at how international environmental law protects a Holocene environment. I think it's fair to say that international environmental law tends to follow a reductionist approach in its efforts to protect a Holocene environment. which means that it leads to a linear, one-dimensional, and segmented, fragmented understanding of what was always incorrectly thought to be discrete, unrelated, sort of localized problems that occur in very specific and disconnected geographical locations. For example, vehicle emissions in Bangladesh is an air problem, it's an air pollution problem in that city, and it has no cascading effects on air quality and global warming elsewhere on the planet, which we now, of course, know is not the case. It does have an impact globally. So in the Anthropocene, a new understanding of the Earth system and its complex, interrelated processes, aspects, and constituents requires urgent changes to governance approaches. And it is only very recently, I think, that the insights from Earth system science have found some purchase in some social science domains like law and governance, with some scholars converging around the idea of Earth system governance and its research agenda, something that my colleague Professor Kim will speak about in a little while. But while some sustainability scholars are starting to grasp the importance of Earth system thinking, the same, I think, cannot be said for environmental lawyers. We still don't think in terms of systems. So practically speaking, the lack of appreciation for systems complexity in international environmental law can, of course, lead to the prioritization of one environmental problem over another. And it reinforces the creation of siloed regulatory regimes, which may lead to problem shifting between separate planetary boundaries. And now we know in a recent study published by the Potsdam Institute of Climate Research that 6 of the 9 planetary boundaries have already been crossed. So if we do not integrate or better coordinate international environmental law institutions in line with how planetary boundaries are interacting in this integrated Earth system, we run the risk of protecting one boundary at the cost of another. And it is therefore necessary that international environmental law reorientates itself alongside an Earth system perspective. Another concern is international environmental law's anthropocentrism, something that has also already been mentioned over the course of this day. Because its anthropocentrism means that it is not able to adequately address environmentally destructive and exploitative neoliberal economic development in ways that also address massive global injustices between the global north, the global south, between species, and between present and future generations. And this is problematic, I think, considering that international environmental law is actually intended to protect the non-human world, is it not? And some even believe that international environmental law has been complicit in creating the Anthropocene's crisis. Because our laws reflect and affirm this anthropocentric environmental ethic, they have become part of the problem. International environmental law, and certainly to the extent that it embraces neoliberal exploitative economic concepts such as sustainable development, merely perpetuates this crisis and is reduced to a means of suppressing the symptoms. We are not tackling the problem at a systemic level. Now, the foundations of international environmental law's anthropocentric ethic were already laid in the 1800s when the first environmental treaties were designed. And all of these sort of conservation instruments pursued very narrow interests that were focused on a utilitarian anthropocentric state economic benefits. And this trend continued throughout 1972 with the Stockholm Declaration and its very explicit anthropocentric ethic that it embraced. And states continued down this human-centered, exploitative neoliberal path, or the so-called environment versus development path, also in 1992 and 10 years later with the World Summit on Sustainable Development. and with the blanket endorsement of this haloed, somehow sacred idea of sustainable development, which in fact is not sustainable, all of these conferences, and even now the Sustainable Development Goals, have further promoted international environmental law's neoliberal, development-biased anthropocentrism. So a central point of critique is, I think, that sustainable development is an eco-political project which might neither be sustainable nor developmental. It is a palatable approach to green-wrap the economic and political project of sustainable degradation that is already now fully in play. And more concrete evidence, certainly, of the failures of sustainable development as the world's current central development vision is presented by a recent study that evaluated the political impact of the SDGs. And one major finding of the study was that the SDGs have not been able to promote planetary integrity in any meaningful sense. There's also concerns about normative ambition, and nothing to me captures that most or better than Boris Johnson's sort of evil look when he engages with President Modi during the UN climate change conference in 2021. I think with very few exceptions, the substantive norms of international environmental law are not sufficiently ambitious to limit human behavior in a way that could safeguard planetary integrity. International environmental law inevitably seems to chase the lowest common denominator that is shaped by political and economic interests, and it remains unable to achieve the deep structural reforms because it is constrained in its efforts to develop this necessary ambition. And this is obviously as much a matter of political will as it is a matter related to legal reform. International environmental law will only be reformed, and its ambition can consequently only increase if there is the political will to do so. But as long as deeply vested political and economic, including corporate, interests prevail, it is unlikely that international environmental law will increase its ambition. And we clearly see the lack of its ambition during every year's climate conference of the parties during the climate negotiations. And we will now see it again in Dubai in a couple of weeks. States are unable, despite the science being there, despite the IPCC reports clearly telling us what the state of the climate is, states remain incapable or unwilling to increase the ambition of law and governance to respond to what the science tells us is actually happening. And that, to me, is extremely disturbing. That being said, and the most negative part of the talk is over, I'm happy to say, looking ahead and perhaps trying to find a solution for all of this, I want to explore three interrelated proposals which I think might be able to reform international environmental law. And many of these proposals hang together with what is being discussed at this conference and to its central theme. The first one is Earth system law. I think for international environmental law to better respond to integrated Earth system governance challenges, it must embrace an Earth system perspective. And scholars have been, or are increasingly exploring alternative Earth system-oriented visions of international environmental law. And there are terms, for example, from Klaus Bosselmann, who many of you in the room would know. He calls it Earth-centered law. There's planetary boundaries law, or the law of the Anthropocene. But something that Professor Kim and I came up in 2019, some years ago, although it seems like yesterday, was the concept of Earth system law. And that there is the paper that introduced it, and we're very happy to say that it seems that the concept has been taken up in the scholarship, and several other publications have been coming out related to this, and we are very grateful and humbled that it is being picked up, although not everyone necessarily agrees with it, which is a good thing. In essence, I think the project of Earth System Law offers an alternative framing for international environmental law to facilitate the type of transformations of law and governance that we need to see in the Anthropocene. So Earth System Law is not a new body of law somehow, such as human rights law or trade law or corporate law. It is rather a way of thinking about the law. It is a framework, a challenging one, that forces us to reintegrate of our basic assumptions of what the law is and what it should do. So this new vision for law, Earth Systems Law, is Earth-centered and acknowledges, therefore, that everything is bound together in a social ecological system that are dominated by humans, but that shouldn't be. So it advances a novel systems approach to law, an approach that merges the systemic and the complex nature of the Earth system and of the legal system into a single operative framework. So in doing so, this framework allows the epistemic traveler, people like us in this room, to explore responses to Earth system regulatory implications of the Anthropocene, such as complexity, inclusivity, interdependencies, and, of course, the need for very radical transformations. And this new legal paradigm also encourages lawyers to grapple much more deliberately, and I think this is important, with the natural science aspects of the Earth system, and to translate these into the social science domain in a way that also meaningfully embraces Earth system governmentality. In other words, how to look at Earth system science and how to translate the relevance of that science for law and for governance. That is one of the main projects also of Earth System Law. Because this is important, as it, when one relies on Earth system science, it creates an opportunity for lawyers to understand the nature and the extent of the problem that we need to address by means of the law, which enables us to fashion any legal reforms alongside what the science suggests will be necessary to solve the problem. I think one other advantage of Earth System Law is that it opens up conversations about the law and about law reform to a much larger audience. While international environmental law, as many of the lawyers in the room would know, has been traditionally, at least, a very much monodisciplinary endeavor practiced by hardcore international lawyers, Earth System Law urges those who research, design, interpret, and apply legal norms to actively engage in inter- and transdisciplinary conversations, in learning and processes of knowledge creation to better respond and understand Earth system transformations. Secondly, I think it would be necessary to think about how to ecologize international environmental law. Certainly also a topic that we've been talking about today. We know now that the Anthropocene crisis is also a crisis of ethics. This has been repeated in many of the talks throughout the morning. We would need to adopt a new planetary ethic. And international environmental law will have to, alongside all of our other cultures and religions and social institutions, embrace and give voice to this new ethic. And the process of developing and adopting a new planetary ethic is preconditioned upon the need to being open to alternative ways of seeing, of being, and of knowing that produce epistemologies of care and humility instead of these anthropocentric epistemologies of dominance and mastery, such as those associated with international environmental law's anthropocentric principles of sustainable development. And I think it's necessary to recognize that these epistemologies of care and humility are predicated upon a relational sense of solidarity that recognizes that the subjugation and the suffering of one is in fact indicative of the oppression of everyone. And one already observes the emergence of these alternative, ecological, sustainable ways of seeing, knowing, being, and caring. For one example is buen vivir that we see in the Latin American context. That also forms the basis of the rights of nature movement there. As a central idea in Andean cosmovisions, buen vivir promotes an alternative to the vision of sustainable development. Buen vivir is a biocentric counterweight to anthropocentrism, in which Pachamama, or Mother Earth, is understood as an ever-present deity who is the source and the sustainer of all life, of which humans are only a very, very small part. And I think what is encouraging is the extent to which paradigms such as buen vivir already exercises a growing influence on Latin American jurisprudence, as we see in the growing amount of rights of nature case law. Now, it's very difficult to find such an ecocentric orientation of law in international law, and certainly in international environmental law. The closest example that I came across is the United Nations World Charter for Nature, which has been, surprisingly, endorsed by the United Nations General Assembly. But it seemed to have sort of fallen off the radar of states concerned, possibly because it is so ecocentrically orientated. And my hope would be is that we again revisit some of the examples that we have, that we don't reinvent the wheel, and that we try to draw on the provisions that some of these instruments that states at least some time ago seem to have agreed on as a pathway forward to ecologize international environmental law. Finally, international environmental law will have to raise its level of ambition. That is clear. And apart from drawing on science, which I think would be key to guide the increase of ambition of law, international environmental law must clarify what its ultimate overarching goal is. The future shape and content of law will depend on this goal. The more ambitious the goal is, the more ambitious the provisions of international environmental law will have to be. And several goals have been suggested. Currently, the goal is sustainable development, and for the reasons that I've argued, I think it's not appropriate or sufficient anymore. Other proposals is something such as planetary integrity, for example, or ecological sustainability, which could be a far more radical ecocentric approach and overarching goal for international environmental law. I want to conclude with a sort of an upsetting quote from the father of the Anthropocene, the notion of the Anthropocene, the late Paul Crutzen, who passed away fairly recently. And he sort of in 2002 seemingly prophetically proclaimed, unless there is a global catastrophe, a meteorite impact, a world war or a pandemic, mankind will remain a major environmental force for many, many millennia. And we will need to foster and champion appropriate behavior, human behavior at all scales, and need to keep that in check. So just as we are emerging certainly from one of the worst pandemics that he prophesied about in decades, the COVID pandemic, we are entering a sort of a new era, seemingly, of intense geopolitical conflicts, where the possibility of the Third World War happening is now more real, I think, than it has been for a long time. And the Anthropocene's crisis might just very well be solved by entirely erasing all humans from the face of Earth, or at least substantially diminishing our geological powers. But I do think that a much more constructive approach to ensuring planetary integrity would be to take up this daunting task to try and ensure appropriate human behavior at all scales. International environmental law can never be a complete solution for fully addressing on its own the complex task of governing the Earth system. But it will always remain a critically important tool in our toolbox because it remains one of the most effective tools of social organization that we have at our disposal. I think that international environmental law, as a technology of social organization, has a lot of catching up to do and will have to reorientate itself much more deliberately to the new context and the deepening governance challenges of the Anthropocene's converging crisis, if it wants to be successful in doing anything meaningful about this crisis. Thank you very much for your attention.
Thank you, Professor Kuze. He talked about the international environmental laws and what is the limitations of the IEL and how we can get over those challenges and the limitations of the IEL. Thank you very much for the wonderful talk. For the questions, and we're gonna have the discussion session, and during the discussion, we can get some questions. Thank you very much. Please give him big hands once again. Thank you very much.
두 번째
Now I'd like to welcome the second presenter, Professor Kim Nak-hyun. I was able to learn from Professor Kim because he's quite famous, and I expected a middle-aged man, but I was really surprised to see a young man. Professor Kim actually have involved in the research in this sector. He studied international environment in Australia, and now he is teaching at the University of Whitlet University, and he is also serving as an associate professor. So as far as I know, Professor Kim is interested in global governance and the international law and how to improve harmoniously with these two subjects. So now I'd like to invite Professor Kim. Please welcome Professor Kim with a big round of applause. Thank you very much, Professor. Actually, I'm older than you think. I look quite young, frankly. I'm 40 years old. I'm so sorry to reveal my age. Maybe I'm not that old, but I'm not a graduate student, so I'm not that young. Thank you very much for inviting me. I don't know if I'm qualified for being part of this conference. This morning, I learned a lot from your discussions. Today, I'd like to share my thoughts with you. So today, my talk will be about Earth system governance. I will briefly introduce about the concept, and I'd like to pose 3 questions regarding this topic. What kind of governance we need? So I'd like to start by asking you a basic question. So we'll delve into the first question. So also we'll reflect what kind of governance we have and how we can transform this system. So first of all, I'd like to talk about the Earth system. For us to talk about Earth system, we have to understand what the Earth system is. According to the Earth scientists, Earth is an object for research. So through modeling that we have come to great understanding of Earth. So if we look at the history of Earth system science, I'm not quite sure where we can go back. However, one popular theory is going back to Gaia theory. In 1970s, James Lovelock and his colleagues came up with the Gaia theory. So I'm sure that you're familiar with the Gaia. So this is if the earth is only existed with only one flower and on soil, then how the flower is going to survive. So if there is a white flower flourishing, then there will be more temperature going up. However, if black flowers bloom, then the temperature will go down. So if so, then the white flowers will bloom more. So that's a popular daisy model. So through this concept that we know that Earth is an organic being. So many earth scientists refer to daisy model and Gaia theory. And in this picture, there are no humans. So actually in the Gaia 2.0, humans are included. In the first version of Gaia 1.0, humans were not put into consideration. However, in the version of Gaia 2.0, that it shows how humans have destructed the earth. But also one thing to highlight here is that the humans also have the solution to the self-destruction. Humans have the tool and also the ability to reflect on the destruction, and we can reflect such self-remorse into the decision making. So this is in the Gaia 2.0 that we know that the humans can reflect on our wrongdoings, and also we have the reflexivity, which can reflect on our next decision makings. So the fact of having such ability helps us to change the trajectory of the current trajectory. So the Earth system was in Holocene, but because of the human activities that the Earth is going beyond the Holocene base. But if Earth goes beyond the Holocene basin, then it will enter into a dangerous zone. So we have to move Earth to safe and just planet basin. For us to change the trajectory, humans and nature have to restore the relationship. So humans need to rethink how we can reconnect to the nature. We have to achieve a symbiotic environment. Depending on the choice that the human race chooses, we can continue to continue the Cenozoic, or we can we can stand at the edge, or we can be the last generation of Cenozoic, or we can create Ecozoic. There are approaches that we can make to change the trajectories, but this kind of approach has been contemplated for a long time. In the 1990s and 2000s, the Earth system engineers and scientists had said. Also, Professor Kote mentioned that if you pay attention to the last quote that he used, that engineers and the scientists have to play a big role, and that we should be able to manage the planet. That's one of the emphasis that we need to remember. We have to manage, we have to engineer the planet. So, for example, we can look through this paint. So the geoengineers have to work as doctors, and we have to understand the geo system and open up and diagnose and intervene in the process of fixing the problems. So geoengineering has been touted a lot in this process recently. Since we don't have enough time, I can't go into every situation, but in the stratosphere, we can put mirrors in the air so we can reflect sun to the universe so that we can cool down the universe. So that is one of the approaches in engineering perspective. But this kind of solutions or the approaches have many issues. I personally believe the reason is because there are two reasons. First one is that I think that we are overestimate the human beings, our ability, because you see this earth is a complex being, but we tend to think that the human beings can fix problems and because we overestimate our abilities. And I think also that we tend to we tend to see our complex society in a simple manner. There are different interests, different needs, but we have failed to reflect various needs and interests of different societies. So there are scholars who criticize Earth system management is more like having a commander in the spaceship, and the commander has the authority to direct the Earth to go to a certain trajectory. So we need to have some critical perspective. So these are the opinions of some scholars as well. The reason I explain this kind of concept is to bring up this issue of Earth system governance. We don't say Earth system management, we say Earth system governance. It's because that we are living in a society with multiple stakeholders which need diverse and decentralized governance. We need to ask these questions: what kind of future we want, and how do we accommodate various opinions? Because we don't have sole society, we have diverse societies, and whose ideas should be reflected in the final decision, whose knowledge, whose scientific knowledge should be reflected in the final decision making, and who will be sitting at the decision making table. I mentioned earlier about the complexity, who should be responsible for the final decisions. So Earth system governance is disciplinary that scholars have to work on these key questions that I asked. I briefly introduced about the Earth system governance, so now I'd like to go to the key questions that I'd like to ask. What governance should look like? I don't think there is a panacea, but I'd like to come up with one example. Elinor Ostrom argued that there is no panacea, so all the governances and all the initiatives should be experimented. So polycentric governance should be an option in the structure-wise. There should be diverse decision-making centers, and their opinions should be mutually adjusted and create synergy. And diversity should be respected. And by going through numerous experiments, successful models should be introduced and scaled up. So all these activities and initiatives should go toward one collective direction, and then that is a framework of polycentric governance. Then there are human races in the world. Then what kind of a polycentric governance that we need? There are different opinions, of course, but from the perspective of Earth system governance, we should operate in the planetary boundaries. Earth system boundary is a new concept. It can be considered as an environment boundaries. I mean, after the environment boundary, the concept was introduced, then some scholars argue that there should be a societal concept. So these two of the concepts are combined as Earth system boundaries. So for us to remain in the green corridor, then what kind of Earth system should be reflected? Of course, we need to systemize the governance. We have sustainable development goals, and that's one good example. I don't think the sustainable development goals have been effective. But anyway, that we need a coordination to create synergy. And we need to downsize the related concept so that this concept should be downsized to each nation so that the individually and also the corporations and the national governments should know their responsibility. That is also one part of justice, and democratization is one way, because what I'm trying to say is that decision making should be democratized. If you look into the Earth system boundaries and also the planetary boundaries as well, but if you open it, then you will see that only 20 or 30 minutes or so researchers come up with these ideas. Then we have to doubt if these limited number of people can represent the whole human beings. So science should be democratized, and in this process that the human voices should be democratized. Then what about the voices of non-human species? So in that context, democratization should be considered. And these four concepts are the focus of functions in operating the Earth system governance. Then where are we standing? If the direction is the one that I just explained, then where are we standing? It's been 15, 20 years since this Earth system, the governance concept is introduced. About 600 to 1,000 researchers are working on this subject, and this is a research framework of Earth systems research framework through 5 research lenses. They are using these lenses to understand the Earth system governance. Of course, I cannot cover all the research lenses, so my research is mainly focusing on architecture. The building block for the architecture is international institutions. International institutions serve as key building blocks of global governance. So these international institutions serve as basic blocks. There are many of them. In the environment governance, more than 1,000 environment-related treaties are created. I asked three main questions: whether these international institutions are effective, are they individually effective, and these institutions interact. But when they do that, do they create synergy? I study on this kind of interplay. And if we look at this whole thing as a whole, is the whole greater than the sum of the parts? So if I give you some answers that the individual institutions are not effective, one of the reasons to do so is almost all international institutions are made in the assumption of Holocene, and then they are not relevant in Anthropocene, so they are outdated. So if we look at the interplay, so through interplay, that synergy is created, but in many, many cases, there are trade-offs and also conflict, and then they are shifting problems each other. And if we look at the whole system as a whole, you can see how fragmented the system is. You can see how synergistic the operation process is. So it's a good indicator to see how fragmented they are. So if I give you only the results, then of course we cannot avoid conflicts. However, it is way more than we ideally think. Then what's the answer? How can we solve these problems? As a solution to such conflicts, the UN proposed SDGs, and UN adopted SDGs, and then SDG has contributed to uniting the international organizations. Until 2015, 2016, the fragmentation decreased. However, after SDGs, the fragmentation have worsened. The reason behind is that behind the 17 SDGs, the fragmentation have worsened surrounding 17 issues. So silos are strengthening. Then why is that? If I may briefly explain why. I think SDGs inherently have fragmentations. It's because it reflects the existing international system. And the 17 goals have 169 targets. So countries and the companies can do cherry picking. And powerful actors water down, and they watch the effect of SDGs. So as a result, SDGs have very limited political effect. And also, Ricote mentioned that the ineffectiveness of SDGs. Then how can we transform the governance? That I'd like to briefly explain about the international Earth System Law. As Professor Kote explained earlier, Earth System Law doesn't necessarily mean to environmental law. But my research has been focusing on international environmental law. There are two dimensions unpacked to use to unpack environmental law in two perspectives. So first, a dimension was international law, global transnational law, and planetary law. And the other dimension is dividing the law into environmental law, ecological law, and earth law. So how can we go from the left upper side to the mature version to planetary earth law, which is the right bottom? I contemplated the ways that we can go from environmental law plus international law to the planetary earth law. I believe various efforts should be put in place. For example, for us to achieve international environment law, we should embrace non-state actors. So the international norms from the non-traditional sources should be reflected in the international lawmaking. Then we can go toward global environmental law. And these norms should reflect ecological values, then we can achieve global ecological law. For example, a good example is Earth Charter. It was introduced as an alternative to 1992 Rio Charter. And by embracing ecological efforts, that if countries embrace, then we can achieve international ecological law. And then that's the example that Professor Kote used. And a good example is World Charter for Nature. And if we move on further to the radical side, if we embrace more radical norms like UNGA Harmony with Nature or UN Declaration of Rights of Mother Earth, then we can create the International Earth Law. And in this regime, the states will serve as trustee of Earth. But if we move further, not only states, but humanity, if humanity can assume the role of trustees, then we can go to global earth law. But if we achieve more sustainable condition of earth, then one example is Paris Agreement. We have to achieve 1.5 degrees. That's a specific target. However, that it includes only one planetary boundary. However, that's not enough, that we need to respect diverse planetary boundaries. And if we do so, then planetary Earth law can be created. Planetary boundary is also human-centric because the boundary is suggested for to provide safe space for human. But do we need to ask if this this space is safe for non-humans? So if we consider that as well, then we can achieve global Earth law. And the most mature system is planetary Earth law, in my thinking. In this system, that human and non-human can live as cohabitants. And then when we assume these roles together with non-human beings, we can share universal norms. So jurisdictions will be meaningless. And Professor Kotze suggested the concept, planetary commons. Indian monsoon or Amazon are critical elements. So these critical elements should be protected by law. So there should be given the status of commons. So Professor Kotze suggested this concept, plenary commons. So based on these efforts that we can advance our international law system. If we can achieve mature version of Earth planetary law, I'm not saying that the international environmental law is not necessary. Eventually, we have to go toward a mature version. However, in this process, we have to also consider polycentric governance because we need to consider various stakeholders. Although we have this final goal, I'm not saying that this is the only goal, but all in these arrows, there are areas that we need to put efforts together. So in sum, the Earth system governance is Earth-centered governance paradigm, and all the living beings become the subject of governance. Therefore, variety, diversity should be respected because it's a polycentric governance. I'm not suggesting a certain model. In the highlight that the important element is the systems and planetary. We need to have systems and planetary perspectives, and also interdisciplinary study is very important. And especially the legal scholars should be included for us to achieve Earth system law. So in this community, law scholars and also the role of lawyers have to contemplate it. So the time's up. Yeah, this is the end of my presentation. Thank you. Professor Kim talked about how can we achieve Earth's system governance in the era of Anthropocene. He shared with challenges that we have and the direction we have to go. So we're going to have now discussion. So discussants and the panelists, please come forward to the stage.
들리시나요? 네.
So without break, let's get into the discussion. Before we forget the contents of the presentation without any break, let's get into the discussion right away. And thank you very much for the two presenters. We have three panelists who are going to do some discussion from the Kangwon University, from the law school, Professor Park Dae-yeon, who is a master of the Earth Jurisprudence, and renowned biocracy expert. Sorry. Professor An Byung-jin, sorry. Professor An Byung-jin. And we talked about the roles of the scientist, and we needed to have more scientific approach. And we have a Dr. Kwon Won-tae, who is a scientist. So we have three wonderful discussants, and I would like to give them some time so that they can start their discussion regarding the presentation made by Dr. Kuze and Dr. Kim. And let's start the discussion. And you have 5 to 10 minutes each. And after listening to their discussion, and we'd like to open up the floor so that we can get more questions and continue our discussion. Who would like to go first? Then Dr. Kwon, as a scientist, and you can start the discussion. And listening to your presentation, well, it gives me a headache because the concept is something new to me. But while I was listening to you, while I was reading through the proceedings, I came up with some of the ideas that I'd like to share them with you. My major is the climate dynamics, the science. And I've been following the IPCC report, and I've been engaged in IPCC reporting. And I was one of them. A planetary boundary and Earth system boundary was discussed today. And let me share what I think about those two new concepts. As a person who majored climate science, I was wondering how we can accept the planetary boundary and Earth system boundary and how those concepts came into being. What is most important is this. In any academic society, we focused on the local area, or I would say the knowledge was fragmented rather than integrated. However, to tackle the climate issue, in the 1970s, we only studied flow of the air, only. Only with the flow of the air, we created a general circulation model. That was fragmented. So we were not able to handle the issue because air is only one of the climate. Then people started to study about the key factors. Another key factor was ocean. So people started to study about air and ocean. There was a kind of expansion. And then people started to understand, oh, ocean is not the answer. So people added another factor, climate model. And many of the factors, many of the indicators were included. But what is really important is the knowledge we know. Even though we combine them, we should be able to integrate them and express them clearly. However, sometimes we were missing with the information. For example, the information was not adequate about the air. The information was not adequate about the ocean. The information was not adequate from the ecosystem and from the land, whatever that may be. As we have more and more information, we came up with better science because we got lots of information from many of the sectors. Now people started to talk about Earth system model. It is looking into feedback and interaction among various objects and various factors. I don't think this one is relevant only to climate science. Probably, whenever you want to understand climate and environment, you should have this kind of holistic or comprehensive approach rather than looking into only a few factors. And I personally believe that is how the planetary concept came into being. In 2009, planetary boundary was emerging and Earth system was coined in 2012, I guess. In the planetary boundary concept, actually, initially, it was covering some of the fragmented factors, for example, climate and also acidification of the ocean. So some of the environmental and climate issues were measured in the early stage. That was the beginning of the planetary boundary. Regarding the Earth system boundary, and when I was reviewing the literatures, I know Dr. Kim is expert in doing this. The planetary boundary concept is totally different from the planetary boundary concept of 10 years ago or the 12 years ago. In the past, people tried to use a single concept to explain planetary boundary. However, it is not the case anymore. When the animal is extinct, and then people try to understand that from the ecosystem viewpoint, and for the deforestation and land utilization. In the past, they were two different indexes. However, now people try to view them as a part of the ecosystem. So people come with the word functional integrity, which means each item, each object within the ecosystem should be seamlessly integrated as a part of the ecosystem. So I can say we are making positive progress in developing the knowledge or the concept about planetary boundary. You talked about SDG, but in SDG, as a climate scientist, I studied SDG from my perspective out of 17 SDGs. Yes, there is a climate development goals, but almost all the goals were interrelated to climate change. I would say 10 goals, 10 development goals are related to climate change, like water. For example, gender equality is somehow related to climate. So again, these issues cannot be addressed by the science only. We should have the social and humanitarian approach as well, not just purely based on the science. So Earth system governance is critically important because we need multi-sectoral approach. Thank you very much for the wonderful contribution of the speakers. And you made me awakened and enlightened because my perspective has been broadened thanks to you. While listening to what you say, well, what is the next step? You talked about the governance and the legal system. Then how should we put that into layperson word so that everybody can understand and everybody can act on it? The same goes to climate change. Climate change is critical. This is an urgent issue. And climate change will have significant consequences. And our safety and justice are threatened because of the climate change. I would say human being is selfish. Human being focus only on present me rather than future generation. This one is risky and this can become riskier, but people don't take action. People do not reduce emission. What does that mean? Earth system governance is an important goal and a noble goal. However, all the actors should be able to understand the concept and act on it. We should come up with some practical advice and practical measures. We are talking about it in the expert group, but bringing this concept to the general public is something different. So that can be the next step that we should take. Only then the Earth system governance can be passed down to, or rather expanded to the general public. But what matters is the clock is ticking. We don't have 10, 20 years? Well, we should take action immediately. We should do something meaningful within 10 years. Time is ticking. So I feel so disturbed about it. Climate change is happening right now. So we should be within the safe zone. In the future, after 10 to 20 years, we will be outside of the safe zone. That means what we discussed today should be put into action because that is really meaningful. And that is something that we should pursue in the future. I hope everybody can be on the same page, everybody can understand this and act on it. Thank you.
권은태 박사님께서 실제 이런
So we were able to learn how this Earth system governance has developed. The Earth system started to explain one phenomenon, and now we have developed into a stage where we can contemplate various things. And since we don't have time, that we have to be effectively able to explain that to the general audiences. And now I'd like to give the microphone to Mr. Kwon Won-tae. Oh, sorry, Ms. Kwon just shared her opinion, and now I'd like to welcome Professor An. Okay, I'd like to make a brief share with my brief opinion. So I was actually frustrated to be part of this discussion. When I went to the U.S., I was really excited, but in the first class, that I was frustrated by the legal terms. But while listening to the two presentations, I was surprised to hear the perspective from the politics. So I learned a lot. Professor Park is in the different the committee, and Professor Park and I can work together in the same commission. We are not much different because from these two presentations, I was really surprised to learn that there is not much different from the research questions. I mean, Professor Kim posed 8 questions, but in also politics, I mean, these 8 questions are critical questions. So we are not talking different things. We are on the same pages. So Dr. Kim posed critical questions that we have to solve in politics. And worldwide, we are facing critical difficulties. As two professors mentioned, that we have come to a close point, to the tipping points. It's not only climate, but that we are approaching singularity point in terms of AI. Mogabet, the head of Google X, says that we are approaching fast to the singularity. However, all the systems that we have are too old. Hannah Arendt, one famous scholar, said that if science doesn't pose light to the future, that the spirit of humans will be lost in the past. So he mentioned this several times in his well-known book, and I think we are lost in the dark. Hannah Arendt, I think he lived in a happy life. He escaped the Nazi, but he escaped to the U.S. But he saw the freedom, he saw the light, and he saw the better hope. But the U.S. freedom system had great problems, and then this current generation is going through the difficulties. From 1960s, all the presidents knew about the climate change. They knew that the problem was coming, but they failed to solve the problems. But the two professors proposed critical questions about the Earth's system. However, unfortunately, our current system is not reflecting the new changes. The Israel-Hamas war could have been fixed in 2000s. Actually, there were two good opportunities. The Bill Clinton and the then Prime Minister in Israel, that they had a good negotiation. However, they failed to come to the final resolution. The reason is because that the internal politics had different voices in the U.S. and also in Israel. So the voices of the elected people in the democracy had different voices. Then we need to think about democracy. Of course, it has contributed to developing our human society. However, that they are representing the whole people, and these elected people continue to reflect the voices of the general population. So not only in the Hamas war and Israel war against Hamas, and also the AI and also climate changes, that we are entangled in this situation, in these difficulties. So we are desperate. So by listening to the two professors, of course, I absolutely agree with the necessity of global governance. However, before doing that, we need to also contemplate how we have to think about how we can fix our democracy. Minister Kang suggested the book by Thomas Berry, so we were able to learn the teaching by Thomas Berry, and he once mentioned that maybe we shouldn't use the term democracy anymore. So two professors' presentation created great resonance. But at the same time, we should create a society where we inherit the great fruits of democracy, but we shouldn't stick to the principle of democracy. Professor Kim said that we have to do a lot of experiments, like polycentric experiments. So we have to do diverse experiments. We need to abolish democracy, but still we need to inherit the fruits of democracy in our decision making. Nobody has elaborated this solution, but we have to think how we can make this process successful. So I'd like to ask these two professors, you mentioned about the Earth system governance, but in one country, who should we exclude or who should include in our decision making? Can you please elaborate that? And then what kind of relationship that kind of decision making has to democracy? Is it enough to include more people? Who should we include and who should exclude? And then do we need to include more people? And then what do you think about democracy in this relationship? Do we need to fix the current system? Do we need to revolutionize UN, because the UN, the system is not working. They are not working to stop the Israel-Hamas war. So do we need to create a new thing, or do we need to fix the existing system?
교수님께서 매우
Thank you. That is a really serious proposal. We are facing the crisis of the governance. There is a gap about the governance. How best we can address that was the question raised by Professor An. Last but not least, I would like to invite Professor Park, and from the Earth jurisprudence perspective. So what do you think about this? First of all, thank you very much for the presentation. My discussion will be based on a single question, but let me give you a kind of prelude. And based on my understanding on the Earth's jurisprudence, I would like to spend some time. The Earth system law. And I read the article just about 3 years ago. And I came up with this kind of new concept when I did not know even about the Earth's jurisprudence. So it was too difficult for me. But anyway, thanks to this opportunity, I was able to listen to the author of the articles that I encountered 3 years ago. So I was able to understand what is the difference between the Earth system law and Earth's jurisprudence. What can be the difference and what can be the similarity between the two. We published a book about Earth's jurisprudence, and the publisher said we should change the title, A Law for the Earth, because he thought that the concept was too difficult to understand. But if we change the title as the Law for the Earth, it means there should be a legal system to protect the integrity of the Earth. But as I was studying the Earth's jurisprudence, I can say the core idea is what is the foundation of the law. The core of the law, according to Earth's jurisprudence, is the Earth. That is the core. The Earth is the very source and the very core that is generating a kind of the norm, or the Earth is the lawgiver, the first lawgiver. The kind of core or the source of the law has been studied a lot, and there are two ideologies regarding what is the core or the source of the law. The first one is based on the nature. The second one is based on the utilitarian approach. And I would say the Earth's jurisprudence is standing on the history of the law of nature. According to an ancient philosophy of China, people follow the earth. And we have a kind of the morality that comes out of the nature. And it has been translated into a model. That can be translated into model. Earth's jurisprudence means to study the mechanism, how the earth is working, and the human being should follow the model of the mechanism, how the earth is working. So in that sense, we can say the earth model is a kind of norm, because human beings should follow the earth model that can be regarded as a great law, and human law should follow the great law. Self-making is really important in the great law. And the third one is relations, and the first one is the differentiation. Based on natural science, the great law can be created, and the great law is something beyond the human law, and human should follow the great law. And one means what is really important is we should follow the natural law, and we should generate self-regulation according to the regulation of the nature. It is more like a self-regulation based on the nature. This is the model that humans should follow. That is why the earth or the cosmos is the first lawgiver. Then, Earth system law is based on the science of Earth system, and normative indication should be derived out of the Earth science. Probably that is why the word Earth system law was created. Dr. Kim came up with 8 research questions. For example, whose ideas and whose knowledge should be put onto the table, and who are the right stakeholders, and how the goal-setting process should be made, and how we should change the society, and how we can reduce the uncertainty, and who should take the responsibility. There were 8 topics that have been discussed. As Professor An said, that is a classical topic within the political science. That is one of the core topics within the political science. When we approach these goals from the Earth system law, the regulatory implication should be generated. And I'm not sure whether my understanding is correct. But let me put it this way. I saw the 2x2 matrix, international, global, planetary, and the ecology, Earth, environment. And I can see the x-axis and y-axis. I believe that can be a great framework that Dr. Kim provided. What is more interesting for me is how the international becomes global and how the global goes to the next step. That kind of pathway was really interesting for me. And regarding the Earth system, what kind of path can be the right path to build the Earth system? Not just normative implication and technical implication should be studied. Yes, that is a concept beyond the Earth jurisprudence. My question is, Earth system law, in my understanding, is correct or not? That's my question. If my understanding is correct, Earth system law is covering this kind of classical ideas, and how much progress was made, and what is the future task for Earth system law. The presenter talked about the pathway and how best we can find out what can be the good pathway. That kind of tools or mechanism can be really important. The legal personhood is a kind of pathway within the concept of Earth's jurisprudence. For example, human and non-humans should be sitting on the table as a stakeholder. The non-humans will have the legal personalhood, and they can be a stakeholder within the concept of Earth's jurisprudence. Then we can step into the planetary discussion. The pathway or the tool is really important. My question is, the Earth system law has any kind of tools or the pathway that it can suggest? Thank you very much.
제가 발제
We have listened to the very difficult questions, and the two professor must be find it very difficult to answer the questions. So, first question was, how can we help the general audiences to be better acquainted with the Earth system governance, the concept? And the second question was that in the presentations that we dealt with international system, in the international scene that we are failing with many systems. How can we apply this Earth system governance in a national level? While having dinner yesterday, the Professor An and I had discussions about the failing UN. And the number 3 is that Professor Park understood Earth's jurisprudence. He understood Earth's jurisprudence in his understanding, and he'd like to know how the Earth law can be used as a pathway to achieve Earth's jurisprudence. So, two professors, that you can choose a question if you like. I mean, all 3 questions were very difficult, but you can choose one if you like.
There, is it? Yes, there. Thank you very much for these very rich questions and for this critical reflection, and also the challenging questions, certainly. I'm sure that there's no right or wrong answer to any one of them, but perhaps just to speak more broadly on some of the points that have been raised while attempting to answer some of the questions that you so clearly pointed out. I think that part of the answer or the solution in moving from the conceptual debate that we are having to a more practical solution would be to exploit this notion of polycentrism that Professor Kim has also noted. And I think there is a lot of potential. What we are seeing today in society, the rise of social movements, social climate movements, for example. The courts are increasingly stepping up as very important actors in environmental governance, certainly in the area of climate litigation. We are seeing an increased role at the urban level, for example, in cities. We are seeing an increased role and the influence of the media, both positive and negative. Of course, social media is often very polarized, which also has its dangers. But I think that the media certainly also can play a very central role in this polycentric governance model. And then certainly scientists and practitioners like us who sit in this room. I think there's both a duty on us and a tremendous opportunity to translate these concepts both into practice and to show to the outside world, as it were, what can be done. And there is a lot of energy, I think, in many of these movements that I've noticed. And to me, certainly, it is very different from what you have all rightly said. the failures of the United Nations system. I'm not very optimistic that we will find a miracle solution at the UN very soon, if at all. I think many of the innovation and possibly the solutions that we see and would need to see going forward would come in a more bottom-up way from actors that we expected the least. So that would be my response to that aspect. And perhaps also one point, in moving from sort of the plan to the practice, I think humans are so inherently, humans only respond to a crisis if we perceive it as a crisis. And we've seen this with the COVID pandemic, for example. We actually managed to respond to the COVID pandemic because at one point we recognized, but this is a crisis. We need to close everything, and we did. Many people suffered, of course, unmentionably so. And restriction of freedoms and so forth. And so we've all been there and we all experienced it. But I think that once we perceive the climate crisis as crisis, we would be able to produce sufficient social regulatory institutions to confront that crisis. And as a last point, perhaps, I think that this movement from international law to transnationalism, to a system-orientated form of law and governance, we already see this. We already see this with the steady progression from what used to be this top-down, centered state governance, where the government tells you and makes the laws and the policies, to this gradual emergence of alternative actors within the governance paradigm, such as the media, such as social movements, and so forth, who are playing an increasingly important role. And this, to my mind, is extremely beneficial to fostering the type of transnational processes that we already see and would need to see much more in future. Thank you. That would be my response for now. Thank you.
님께서 또 질문에 대한
And Professor Kim, can you answer the questions? Thank you very much for the questions. These were difficult questions. I don't know if I can answer to these challenging questions. First of all, I think, the science policy interface related question was the most difficult one, I think. And how can we put this concept and the theory into practice? How can we appeal to the general public? That is the question that I am grappling with every day. I don't have the answer, unfortunately, but that comes to my mind. I used a geoengineering example. I think it will come to our face. I mean, it will come to very immediate in front of us. Although I don't want that, then we will be able to. I mean, we should be able to modify everything, all our daily lives. Then we will need bigger governance. So when the time comes, then if we realize that we need necessary governance, although it will be a very unfortunate occasion, that we will come up with governance. And also, Professor An asked a question about democracy. We need to have sustainable decision makings in the global democratic scene. I'm not a specialist in democracy, but the Global Assembly in the system that we can select like 500 people. It's like jury system. So it's like a jury system that we can randomly select 500 people and then have them represent the general public's voice. I mean, it's experimental. So in the existing system, UN Trustship Council is one option. By reviving the system that we give the responsibility as a nature trustee. I know that there is discussion like that going on. And one state, one vote system is not working. But then consensus basis system, I mean, it's not working too. Then depending on the responsibility and power responsibility that we can give different weight to different countries. I know that there are different discussions going on like that. And for us to and also we can hear opinions through online, but that also that we can raise questions like do people have all internet access? I think currently the UN SDGs 17 goals are too many. There are trade-offs, and then we need to have better goals. And I mean, there are clearly trade-offs. And Professor Park posed very, very difficult question about the system governance and the law difference. I think if you ask question to Professor Kote and to me, then they will both have different answers. Personally, I think I proposed a framework for the concept that I think we have to fill the blank in the framework, that we provide only broader definition, but we didn't provide the concrete context. I mean, of course, I have my own opinions, but I didn't want to fill all the framework with my opinions because I didn't want to give too much influence with my own thoughts. There must be different opinions. I think the Earth's governance has a holistic view, but the law has different perspective, holism. Because in holism, things are all connected. But in the system view, we have to identify that which ones are interlinked and how they're different in the dynamics. So we have to create governance measure with these different understandings because there are clearly system differences. And also you mentioned about the nature. I'm grappling with the concept of nature. Do we include nature in the Anthropocene? Then if nature is not included, then where should we go back? If we leave nature as it is, and is that the status quo that we want? Earth system law is non-centric or non-centric, which means living the nature as it is. There's no dualistic distinction between the two systems. And also, one more thing that I'd like to mention lastly. So socialists and the humanist researchers and also the person who is working on the legal concept, I wanted to explain the concept and the core. Of course, there must be differences in these differences, but we need to find commonalities in these differences, and also we need to find ways that we can complementing different concepts. And in these areas, we have to think how we can successfully collaborate with different concepts. Thank you.
두 분의 어려운 질문
And thank you very much for the answer. We have around 10 minutes. I want to open the floor. If there is any question from the floor, you are free to ask a question to anybody. If you have a question, we can open the floor and get some questions from the floor.
네, 저희 한국환경연구원의 한상훈입니다.
And Han Sang-hoon, who is the Environmental Research Center, Dr. An said we should abandon the word democracy. I do agree with you, in a sense, but it is not going back to dictatorship. And can you answer? When we abandon democracy, should we go back to dictatorship or the authoritarianism? And sometimes there can be legitimate authoritarianism. My question goes to you. And can you elaborate a little bit more? What is the ground or what is the reason behind that you say we should abandon democracy? Because that's why you raised the question.
소위 가버넌스가 많다.
You said that there are too many governances. So these governances are fragmented and not effective. That's what I understood from you. It may sound too contradicting. I'd like to give you a Korean case. In Korea, the regional governments are working hard to implement SDGs, and Jeju Island is one of them. And Dobonggu area, Dobonggu district, has set up a SDG commission. And Gangbuk-gu district has mountains like Dobong and Gangbuk. But despite the committee, they don't necessarily understand SDGs. We need to have grassroots groups to implement SDGs. High number doesn't necessarily mean good implementation of synergy. Since my opinion is a bit contradicting, I'd like to ask your opinion, Professor An. And Mr. Park?
And regarding democracy again, and you talked about the pathway, and participation can be a way of the pathway. And there are many of the attorneys from the law firms, and they are wielding their power from the offenders against the nature. And even though we have an agency that can speak for the nature, probably they cannot speak on behalf of the nature because they cannot communicate clearly. Well, probably we should think about how best we can have the better agency rather than just the traditional agency for the nature and non-humans. There were 3 questions regarding democracy. Dr. An, 1 minute please, because we do not have a lot of time. Just 1 minute. Thank you very much. Let me be brief. What I mean is, we should go beyond democracy. We should be creative about the governance, just like a polycentric governance. It is high time for us to think about the polycentric governance. Harvard University thought about the sustainable future, And when Dr. Faust was the president, he was not elected. He was not elected. And throughout the governance process, he was elected by the board member. It was not based on democracy. He was rather appointed. So in that case, the democratic process is not always good. And there is a UK-based company, they have another set of the governance. Democracy is necessary, but in Korea, we should go beyond democracy. We should be more creative, and we should explore more governance. This can be a little bit dangerous, but authoritarian regimes will be coming in. The fascism or the authoritarian interventions will be made when we have the climate crisis. The eco-fascism is taking place in Australia, EU, and US. Of course, we cannot rely on fascism, so we should have the due process, which will be a little bit authoritarian, but the process should be legitimate enough. Just like two processors said, we should do everything we can do to fix what is broken right now. Of course, we should get prepared for the worst case. We should explore that. Life does not go as you expected.
아마 김낙현 교수님께 드렸던데 사실 저도 약간의 질문이 있었어요. 아까 말씀하신
And then he also asked a question about the polycentric approach. There are many international environment laws and institutions, but they are not that efficient. But, the many institutions mean that the polycentric concept, right? I think there is confusion in it. Can I elaborate on democracy a little bit? When I teach my students that, I ask this question. Do you want democracy? Or do you want dictatorship if we can address sustainability issue? And then many, good number of students say that I'll embrace dictatorship. So I think that discussion that you just posed will be valuable discussion. Actually, I haven't used effective, ineffective. I think the efficacy and the effective, they are different. If we go for effectiveness, I'm not saying that the smaller number of institutions are required for effectiveness, but what I'm trying to say is that there should be a less number for different reasons. Yeah, yes, definitely, I agree with you because MDGs are not working well. Then how can we have larger governance? But while working on this subject, that I realized that there are many cherry picking, and then you can easily assume that the economic growth is the most cherry picking topic. GDP is mentioned 9 or 11 times in the SDG frameworks. So many countries are prioritizing economic growth as part of SDGs, and that's why I was concerned about SDGs. But as you mentioned, that all the local communities cannot implement 17 goals there, so there should be the SDGs contextualized depending on the situation.
해주시면.
Last but not least, Dr. Park, let me be short. Thank you for the question. For the rights of the nature, I would say the governance system is changing. In the environmental protection, the state is protecting the nature. However, now the governance is changing. The government, state, and other stakeholders are a part of the governance. We have a more democratic governance. to understand what can be the benefits of the nature and what can be the rights of the nature. And we should align the benefit between the nature and the human. That is something that we should do. And in the middle, our approach to nature, our relations to nature shall become different. Just like in the case of the New Zealand. For example, they have the state and they have the people from the original culture. So they have the two stakeholders at the same time. So that kind of approach can be a different set of the governance. And I believe that can be a really good example because New Zealand is trying to protect the nature and the native New Zealand people. We are almost done. Thank you very much for staying with us till the end of the session. Dr. Kuze said Earth system law is a kind of way of thinking. It is a way of thinking. As Professor Park said, the core or the source of the law is the nature, and we should make that as a norm or the legal system, and then we should come up with some solutions. I sincerely hope this session was helpful in changing our mindset or in the way of thinking. I would like to thank the two presenters and the three discussants. Thank you very much. Please give them big hands.
예, 안녕하세요. 오늘
Nice to meet you. I'd like to welcome you to the third chapter that we're going to today talk about more than human, interdisciplinary research trends and visions. My name is Kim Wang-bae. I am the professor of sociology at Yonsei University, and I'm also the representative of Forum, People for Earth. I moderated for the chapter yesterday, last year, and then last year I was fine, but this year I am nervous. I think it's because in the part 1 and 2, I was able to learn a lot. Makes me reflect on the new knowledge. In the last section that we're going to have two presenters and then two panelists. The first presenter will talk about more than human geography, Mr. Hwang Jin-tae. He is the assistant professor at Dongguk University. And he is a professor at North Korea Department. He has keen knowledge and interest in the inter-Korean relations. And also he he researched a lot on geography, more than human geography. And another presenter is Professor Julia Sayeva. She is a Paler University independent researcher, and she will today talk about, do we need Earth jurisprudence? It means that I think she's going to talk about the re-envisioning human rights to accommodate nature. So she will talk about more than human law. And we are privileged to have panelists, Mr. Kim Jun-soo. He is the researcher at KAIST. Mr. Kim is well known to us. Professor Kim, actually, Research Kim has researched on the pigeons and also the lobsters in the nature. And also, we are privileged to have Mr. Kim Gon-woo. He is the professor of KIST. Professor Kim is majored in the science and technology and also the legal philosophy. He is interested in the commons. So we look forward to the presentations and also the discussions. I'd like to welcome Professor Hwang. Dr. Hwang is given 20 minutes. I wish that we could give some time to the floor so that we can have discussions. When you're ready, please begin.
네, 안녕하세요. 동국대학교 북한
Good afternoon. I am Hwang Jin-tae from the North Korean Studies of Dongguk University. Thank you very much for having me here today. The topic is the geography more than human. You talked about the Earth's jurisprudence, and the more than human geography is something similar to it. So we would like to have some kind of discussion. What is the similarity and difference between the two disciplines? And probably we can have some synergistic impact in the future. So today I'm going to focus more on what is the difference between the Earth's jurisprudence and the more than human geography. So this is the first meeting between these two disciplines. So more than human geography can be covered. However, I cannot cover all the researches about the more than human geography. However, as a person who have introduced the more than human geography concept to Korean society, I would like to share my thoughts and what kind of implications the more than human geography can have. So I'm going to tell you about some of the implications. So there are some human-centric concepts like gentrification, state, or the 주체 ideology of North Korea. And I want to explain how these concepts can be viewed from the viewpoint of more than human geography. We talked about the international level discussion, the governance and the law on the international level. However, from the geography perspective, I want to focus more on the region, something between the global and the national level. So I'm going to focus more on the regional level. That's why I can tell you that we can focus more on the middle range and how we can understand the conflict between the nation states and the region. Of course, I can do some study about East Asia, but I want to focus more on the inter-Korean relations because I am working for the Department of North Korean Studies. I'm going to bring up some of the topics like DMZ and the Korea Confederation, which was suggested as a unification model between the two Koreas. And I'm going to tell you how more than human geography can cover this kind of topic. And maybe I'm speaking too fast. So let me slow down my speech a little bit. And in the more than human geography and the Earth's jurisprudence, what is really important is beyond the human-centric approach. Non-human exceptionalism is really important. So we study non-human, and sometimes when we study the non-human, we simply study non-human, and we simply believe more than human is a kind of the trend. So we should be cautious about not to get too much into the more than human concept. Earth's jurisprudence has been fully covered. This concept has been covered in the morning session. And when I was studying the Earth's jurisprudence, I can tell you this way. The key concept of the Earth's jurisprudence is the relations between the human being and the Earth. In the past, people were regarded as a omnipotent power, but Earth's jurisprudence recognized human is a part of the Earth community. The well-being of the Earth is closely related to the well-being of humankind. We talked about the law and the governance, and human being is a part of the governance of the ecosystem. Dr. Park told us about the Earth's jurisprudence. And Mr. Park defined Earth's jurisprudence this way. The relations between the human and all the stakeholders is maintained, and the legal framework or the normative framework will be expanded beyond the human governance and beyond the scope of the human being, and from the ego to eco. In this session, I heard that harmony with nature members are working for this conference. So, harmony with nature was captured. And it is really interesting that People for Earth is working with a harmony with nature. Earth's jurisprudence is really interesting. And I am not a national actor, and I'm not a famous person, and I am studying only more than human geography. And I was wondering how I can have influence on Earth's jurisprudence. And as a person who is standing outside of the Earth's jurisprudence and the society of this academic society, I can tell you this society is led by Minister Kang, and the key players are the lawyers and the professors of the law school, and potentially you can invite some of the scholars from sociology and artists. And this one is really good. And I believe that more than human approach can be done like this. And we use the concept of the politics of scale. This one is a really important social activity strategy. Let's say there is a local union, and local union can fight against the big company and international company. However, the local labor union is really small because they do not have the national actor, just like Minister Kang. Then they can work with the global trade union and global trade NGO. In that case, the local issue can scale up as a global issue. The local issue will be turned into a global issue, and they can give pressure against the global company. This is the politics of scale. Earth's jurisprudence came into Korea, and usually the jumping takes place from the local to the global, but Earth's jurisprudence has come into the Korean society. The global issue was brought to South Korea, and we can expand the concept in Korea. This politics of the scale is really successful. Many scholars are gathered here today, and many people are gathered here today, so I can say the scale jumping is really successful in Earth's jurisprudence. Then what is the difference between the more than human geography and Earth's jurisprudence? Yes, we have the common factor. The human and ecosystem are not separate from each other, and we want to understand the world in a comprehensive way. And sustainability is really important, and governance is also important. This is the commonality between the two principles. The key difference between the two is this. Earth's jurisprudence looks into humanity, nature, and they are handling some of the universal factors, rights, legalhood, and legal rights. However, more than human geography is more in detail. What I mean is, rather than focusing on the common relations and common value, those who study geography focus more on object and the space. What is the relations between me and to the space, me and to the object? And how should I speak in front of the audience who are listening to me via the internet? So, more than human geography focuses more on micro object, the relations between the object and me, my pet and me, and what kind of affective relations can I have between me and the pet. That kind of unexpected or creative ethics is something that we are focusing on. Earth's jurisprudence defines human being as a part of the ecosystem, and it is giving the message we should not exploit natural resources. Yes, that is the concept of the Earth's jurisprudence. However, the more than human geography is focusing more on the contact point between the human and the non-human object and non-human creatures. In that case, we can have a more peaceful relations. Professor Kim Wang-bae reviewed about the Earth's jurisprudence. And Professor Kim Wang-bae defined the Earth's jurisprudence this way. And the Earth's jurisprudence is beyond the new materialism, and the right of the nature should be clearly defined once again. For those who study Earth's jurisprudence, maybe Earth's jurisprudence is not talking about the rights. But anyway, as you can see here, Dr. Kim Wang-bae is the social scientist, and he criticized the new materialism and Earth's jurisprudence. To materialize Earth's jurisprudence, you should have realistic factors. For example, specialty and individual factors. That's going to be really important. And I personally believe this is the area where the two disciplines should work together. Now, let me tell you about interpatience. Interpatience is looking into the relations between me and the non-human being. This is not based on the physical relations. It takes a long time for me to understand the other object. And there can be interpatience between the two actors, whether it is between the human and non-human. And I believe that kind of interpatience is required between the more than human geography and Earth's jurisprudence. In 2018, I wrote an article about more than human geography, and Dr. Choi Myung-ae also wrote an article about this, and Dr. Kim also wrote an article about the more than human geography. We have a small number of the scholars within the more than human geography. Probably we should nurture our power, and we should nurture more resources and the scholars in more than human geography, because in the Earth's jurisprudence, there are many prominent scholars. More than human geography can be something new. Now, let me introduce this one. I wrote an article about the animal cafe. And animal cafe must be something new, and probably those who study Earth's jurisprudence do not want to go this kind of the cafe. In East Asia, there is an animal cafe. I wrote this article along with my students when I was teaching in the Seoul National University. The animal cafe is covered this way by the Korean media. There is animal abuse. The animal cafe is like a hell to animals. And those who visit the animal cafe does not feel affected about the animals. So media is criticizing the animal cafe. However, more than human geography is not only focusing on the conflict, but we focus more on the compromise. From the well-being of the animal cafe should be abolished. However, we still have the animal cafe, and there are many within the East Asia. How we should understand their existence from social science perspective. So I visited there, and ethnographic research was made by visiting those animal cafes. Yes, they pursue the financial gain. However, the owner was not trying to exploit the animals. For example, the meerkat is digging the ground. However, you cannot dig the concrete ground, so they have the saw sand, and then they are letting the meerkat do what they can do in the wild nature, and they provide some kind of best environment for the wild animals. So they are not simply abusing or exploiting the animal, because they are trying to give the best environment for the animal and for the animal well-being. So once you go there, you can see the context is much richer than just covered by the media. What I mean is, when you go there, it is not always negative. And they also give a kind of the guardrail between the strong animals and the weaker animals to protect the animals. And they have installed this kind of wooden installment to give the better care for the animals. There is a certain reaction between human and non-human. To put it simply, you are exploiting the animal to get some financial benefit. However, this is taking place only in East Asia, and probably the East Asian people love animal more compared to other countries. And there is also the legal loophole in East Asia to create this kind of animal cafe. What I'm telling you is there are various factors for the existence of this animal cafe and whatever that may be. That is why, from the social science perspective, we should have the detailed analysis. That is the core of the more than human geography. I told you about the jumping between the global, regional, local, local to regional to the global. What we want to do is from the transition from the local to the region. The concept should be widely transmitted, and we need to focus more on the spatial characteristics of the inter-Korean relations, and that's something that I'm going to introduce for you today. First, state or the national state. Capitalist state comes to my mind whenever I think about the government or the state. The capitalist state is human-centric. As Professor Kim said, GDP has been mentioned. GDP growth has been mentioned many times within the SGD because, as you know, the capitalist country is focusing on GDP growth. Anyway, I am personally interested in national state and the role of the state, especially in relation to economic development. Then, what is the more than human state? Does it mean a utopia? As you can see, this animal is the one who is issuing the driving license, and he is talking to other animal. This is not something that I envision. And I have proposed this kind of the concept, the state be more than human. And I cannot tell you about the accumulation strategy and the hegemony project. But I want to focus on the factor 1 and 2 and A and B. Accumulation strategy is about the economic development of South Korea, for example, and hegemony project is more like the propaganda or the slogan, for example, like the modernization of the modern nation. So these are the hegemony projects what I mentioned. They are the firm foundation of a national state, and they are legitimizing exploiting nature as a part of the resources. That is A1. Non-humans as a resource mobilized by the extant capitalism. non-human agency has become really important. You talked about the legal rights and the legalhood of non-humans, and you talked about the dolphins in Jeju Island. In the past, non-human has been very passive. However, non-human has become political animal, and how that kind of change will have impact on the politics in South Korea. And there are human beings that respond to other non-humans. That's why we are gathered here today. And when non-humans are hurt, we get hurt too. So we are building effective relations with non-humans. In the past, it was just animal lovers. However, now we have another social group who have effective relations with non-humans, who can have a huge influence on the national power. That is why I came up with this kind of framework. And in the interest of time, let me skip some of my parts. Not only in Korea, but also across the world. Whenever we talk about the political science, state is described as an evil because it is mobilizing the natural resources to get some financial benefit. But rather than describing the nation or the state as an evil actor, we should have a different lens. I don't think it is really helpful just to depict the state as a evil being or the evil agent. Because we should build some effective relations. Yes, states have some negative factors and they can play a positive role as well. Only then we can have more effective international governance. There are various frameworks. Professor Kim talked about the architecture, and if we want to keep the building of the governance, the states are like the pillars, and those states should be very robust and they should be kept as they are. And you can see these kind of movements. For example, how should we view these people? They are protesting for the animal and for the animal rights. Just a few years ago, I tried to theorize the more than human state, and that has not been cited a lot, even though I wrote that 3 years ago, because people are now disappointed about the state. And the role of the state has been recognized in East Asia. That is why I am interested in the power of the state. However, probably those who are in the Western world do not have any interest about the concept of state.
프로젝트를 여기 김주수 선생도 있고 인류학자들
We have anthropologists and we have Dr. Kim here, and we can have some multidisciplinary approach on this.
쪽도 같이 이제 좀
With the scholars in the East Asia, we can have more study about the more than human state.
연계해서 다시 모든 휴머나이징 된
And more than humanized governance model can be materialized in the future. I have only 4 minutes. I wish I had 2 hours, but let me tell you about gentrification. On the second paragraph, you can see there are some phenomena taking place in the Western world. The middle-income white people are coming in to the newly modernized world, and animals come with those rich people. There are hospitals for the pet, and there are parks for the animals. It's more like a apartheid. sometimes a certain human being will be excluded in these dynamics during the process of the gentrification. We had a kind of the classification based on the gender and the race. However, now we are dehumanized and we sometimes become beyond the human because of the gentrification. And there are cats living in the old town, and how the cats can be replaced along with the gentrification. And probably we can have a thought about the more than human rights to the city. We talk about the more than human geography, but we should think more about the human and non-human. What we are doing for the non-human is for human. What I mean is when we have the interaction with the non-human, it makes me feel happy. And there is a museum within the Seoul National University, and there is a cat. The cat died a few years ago. However, many people try to memorize this cat, and I felt so affected about this cat. Whenever I see the cat, I feel happy. So these are the pictures I took. So this is the affective relations between human and non-human. When we talk about more than humans, the relations with the more than humans is for me, for myself, for the human. So that is why the non-humans have every right to live in the city and in this world. And we had a discussion about the stray cats that will be left behind whenever new construction development is made. Yes, this is a politics that is working in the relations between the human and non-humans. This is a 주체 ideology of North Korea. Yes, Juche ideology is a human-centric approach. However, there is a researcher who criticized the non-human centralism. So this is a very interesting area for the future study. In North Korea, there is a transition to more than humans, but let me skip that in the interest of time. Now it is high time to talk about the commons. Commons is really important. State, market can utilize the resources. However, they should utilize the resources in a sustainable way. However, because of the exploitation, we cannot be sustainable anymore. That is why many people talk about commons right now. To manage the commons, who can manage the commons? Is it human or the non-human? And within the more than human geography, we should think more about who should be responsible about the commons, the resources, community, institutions. However, we still have a question mark. I quote Dr. Kim Wang-bae once again, the relations between the Earth's jurisprudence and commons. Possession was a kind of key word. The private property and Earth's jurisprudence, that kind of relations has been studied. So possession should be clearly tackled. The private ownership should be clearly addressed and handled. Otherwise, we cannot fully address the issues about the more than humans and the issues related to commons. I tried to build a model for the commons and how the commons can come into the urban planning and urban development. On the left side, you can see what can be the governance for the co-development, what can be the key strategy for the commons and its approach. Also, we came up with another commons that is coming from the renewable energy sources and how we can build the energy citizenship. And I have made a study from the macro perspective to micro perspective. We should build a really attractive model. However, from the academic area, we cannot do it and we are not able to do it. And from the policy sector, and they are trying to come up with a better model. And I believe that is the joint study area between the modern human geography and Earth jurisprudence. That's it from me. Thank you very much.
예, 황 교수님 감사합니다.
Dr. Huang, thank you. And we can have 2-day session along with Dr. Huang. That's really interesting. And he quoted me and Minister Kang a lot, anyway. And his topic about the DMZ and the commons can be further discussed during the discussion.
선생님.
Now I'd like to welcome Professor Julia Sergeva. Do we have Professor Sergeva? Yes, I can see you well. Yes, I can hear you well. I can see you well. You have 25 minutes, more or less.
예, 예.
So first, good morning, everyone. Good afternoon, and good morning on this side of the world. It is for me a really great pleasure to be with you, and so I very much thanks People for Earth and the Sun Pro Bono Center for inviting me to talk today with this great list of speakers. As you know, I will be talking about more than human law, but more specifically, I will be focusing on more than human rights. Let me begin. As we all share this understanding in a conference like this, we find ourselves vis-a-vis a new imperative, which is the imperative to talk about the human and nature together, which is posed on us by the Anthropocene, whether we conceive it as a rhetorical idea or as an actually geological new epoch. While it is, of course, impossible to claim that in the past the two realms were separate or divided and kept completely one apart from the other, it is also true that the new epoch imposes on us to overcome the human nature dichotomy in a different way, abandoning once and for all the desire to keep them separate. I have decided to focus specifically on human rights in order to, face the many challenges of this new overcoming, of the need to overcome this dichotomy. Because human rights offer a very familiar, but at the same time powerful frame that is, according to many authors, very well suited, to promote an ontological revisioning, to imagine different ways to think the human environment interface. They are also very widespread in international law and national law and regional law. And they are therefore a very powerful instrument that we all are acquainted with. They are hence called to enter a new dimension, a dimension able to turn human rights into tools to face the challenges of the Anthropocene, rather than to actually perpetuate the same injustices of the Holocene. And here I'm trying to move with Professor Koze's request and call for adding new tools to the toolbox that we need in order to overcome the challenges of the Anthropocene. However, this further elaboration of human rights is actually it's not such a simple task. Human rights, as we have actually conceived them since their very beginning, are inherently anthropocentric. They were actually born at a time where natural resources were not perceived as scarce. Not that they weren't, but they were not perceived as such. So human rights, when they were conceived first of all, by a philosopher in the 17th century, they were meant as a tool to protect particularly human interest and human needs. For example, from the power of the most powerful rulers, and to accommodate the very basic needs of humans. In fact, traditionally, only human beings may give rise to sufficiently weighty moral demands to justify the creation of such powerful tools of protection. Because as we all know, they are particularly powerful tool of protection. They have special safeguards. They have at the highest level of the hierarchy, of the law in states. And they have whole international law systems aimed at protecting them. Of course, this doesn't mean they are not violated. We're very far from it, fortunately. But this also means that they are still and already a powerful tool, rhetorically and legally. Changes have actually, however, very much occurred in the human rights rhetoric and in the human rights law. And they have definitely accommodated or trying to accommodate as much as possible the limits of the earth. So when we have spoken about, for example, the idea of green human rights, so human rights interpreted in ways that also include environmental issues, or the whole discussion about the right to a healthy environment, whether it's called a right to a healthy environment or right to a health and sustainable environment, well, we have different formulations, but that definitely is one of the great examples of so-called environmental human rights. Or the rights of future generations. The very idea of including future generations as our right holders has actually enlarged human rights ambitions to actually also face environmental issues. And of course, all procedural environmental rights that are related to them, such as, for example, the right to prior informed consent of indigenous peoples, but also of all citizens to be informed about what is actually going on with a new project or a new enterprise that might harm the environment. These are all great achievements for sure in the common protection of human interest as well as nature. And they well demonstrate the deep interdependence between human rights and nature's protection. However, human rights are still bound by their anthropocentric foundations. And when I talk about foundations, I mean the reasons why a human right is recognized, the foundations, the justification for the existence of a right, the raison d'être of a right. And we will come back to this idea of foundations. That's why I'm actually underlining it. Within the current structure of human rights, for as enlarged as they might be, nature still figures as one of the assets through which the protection of human interest may be achieved, or as an interest to be protected for the sake of human beings. Nature is not a holder of its own intrinsic value within the human rights system, or at least is not usually regarded as such. And the aim of human rights is not to protect such an intrinsic value. They are still grounded on protecting the intrinsic value of humans. Nature protection, hence, is limited within the short-term borders of human interest within human rights framework. Nature, therefore, is protected because it is of use to humans, even if the idea of use can be very widely conceived. It is protected to the extent it benefits humans and subordinately to the interest of humans. So its protection sort of finds a limit in human interest. However, by many authors, there has been a very strong call to renovate human rights. And here, allow me to quote Professor Kozé, the keynote speaker of the previous session, when he calling for the creation of more ecocentric formulations of human rights that sees the environment as a condition to life, thus placing limitations on individual freedoms and turning human rights into something more grounded in communal and group conceptions of rights. But now the point is, how can we do this? Can actually human rights be framed to incorporate the vulnerability of the earth and the limits of natural resources and the planetary borders of the earth? How can such formulation look like? And how could an ecocentric foundation, so justification, be incorporated into human rights? And very importantly, what would be the price to be paid for conditioning human rights by ecological considerations? What is the road ahead in this enterprise? And here you will see now I will concentrate on a more specific example to try to distill a few teachings, a few information about such a possible enterprise. And specifically, I would like to concentrate on the idea of biocultural rights, which are an emerging basket of rights that was formulated as an opinio de iure condendo, so as rights that should be emerging about 10 years ago, and that actually go in the direction of merging together indigenous peoples and local communities' rights and the call for the conservation of the environment and the protection of nature. So you will see using them as a proxy. I was talking more generally about the need to incorporate the human and nature, and in this case, I am specifically talking about incorporating indigenous peoples and local communities' rights and the conservation and the protection of nature. But let's see how they came about, this idea of biocultural rights. They came up from the confluence of many different streams, like an imaginary wire that was linked by a scholar who's called Kabir Sanjay Babikate, who actually linked a number of different happenings in international law, which ranged from the higher recognition of indigenous people's rights, so thinking about the UN Declaration on the Rights of Indigenous Peoples or the International Labour Organization Convention 169 on Indigenous and Tribal Peoples. But also together it was connected with the call for a more community-based type of conservation of nature, which meant a conservation that didn't put communities and peoples aside, but they actually wanted to integrate them in the strive, in the attempt to conserve nature. So overcoming the classic dichotomy in this case of people and nature, but actually involving them and avoiding the classic fortress conservation style. So protected areas means taking people out from the area. That was the old style. So this increase in community-based conservation calls. At the same time, also, he linked international environmental agreements with these other wires, such as, for example, the Convention on Biological Diversity, that in Article 8J specifically really calls for indigenous peoples and local communities as holders of traditional knowledge and practices that are relevant for the conservation of biodiversity. And nowadays, we can also see case law that starts to actually mention biocultural rights, and in particular, the Atrato River case by the Colombian Supreme Court that specifically mentions biocultural rights. But what are these biocultural rights? They are the basket of rights of indigenous peoples and local communities, which is required to secure their stewardship role over the lands and water. So basically, they start from the understanding of the fact that there are some indigenous peoples and local communities that have maintained ways of life that are relevant, very important for the protection of nature, which is, this understanding is entrenched in Article 8J of the Convention on Biological Diversity. Now, this goes one step further by saying, well, these ways of life can survive and can flourish only if such peoples and communities are actually secured certain rights, such as right to access to natural resources, right to access to their lands, right to a certain level of self-government, right to cultural diversity. So all these rights are necessary for these peoples and community to maintain such role as stewards of the environment. Therefore, and that's the further step, the recognition of this set of rights, of this basket of rights that we can call biocultural rights, can actually enable and enhance the protection of nature. So you see, this is the line of reasoning of biocultural rights. But now let's go a little bit more in detail of biocultural rights and try to understand what actually they are made of, what their architecture is. What is the foundations? And here we need to ask ourselves, what is the foundation of biocultural rights? So what is the justification? And at the first look, it appears that their justification is the interest of indigenous peoples and local communities to act as stewards of the environment, as stewards of nature, of stewards of biodiversity. However, if we look at this interest a little bit more in detail, we can actually see that it is made up of two different interests. On one side, the interest of indigenous peoples and local community to self-government, to cultural identity, which is, which is made real through their relationship with the environment also. But it is grounded, this interest that we are here protecting is actually grounded or on indigenous peoples and local communities' intrinsic value. It is their intrinsic value that we are aiming and protecting here. However, within biocultural rights, we have a second foundation that we can recognize, and it is the interest in the conservation of nature, in the protection of nature. And this, we can actually understand it as grounded, founded on the intrinsic value of nature. So what we find ourselves with is a set of human rights, biocultural rights are framed as human rights, that is grounded on a double foundation, which itself, a double foundation which is justified on the recognition of the intrinsic value of indigenous peoples and local communities, as well as the intrinsic value of nature, just like rights of nature are, which are grounded on the intrinsic value of nature and its recognition. But now let's see. So within this basket of rights, we will need to include such rights such as rights to land and natural resources, rights to self-government, right to cultural diversity, as well as all the procedural rights that are necessary to make these other rights real, such as access to justice or prior informed consent. But for these rights to actually be real, to be concretized, and for this protected interest to be really protected, we need to talk about the duties and the duty holders. So the protected interests that we witness are self-government, conservation of cultural identity, access to lands and natural resources of indigenous peoples and local communities, but also the protection of nature. Those are the protected interests that we are fighting for with the biocultural rights tool. And the duty holders are, of course, states, international organizations, private enterprises that are all called to protect this interest and therefore to abide to some duties and obligations towards indigenous peoples and towards nature, to act within the biocultural rights framework. However, we have also called into action within the biocultural rights structuring also indigenous peoples and local communities. We are calling them to act as stewards, which is something that they, as we see from many of their declaration of indigenous peoples, usually do, usually want to do, usually strive to be, called the stewards of the environment. But we're actually giving them the responsibility to act as such. So within the biocultural rights framework, we're treating them as duty holders as well. They have the duty to protect nature, to exercise their biocultural rights in ways that are positive for the protection of nature. So with biocultural rights, we can see that the implementation of biocultural rights must promote the interest of indigenous peoples and local communities on one side, but also their implementation must promote the protection of nature. Therefore, sustainability, being sustainable and remaining sustainable, becomes a requirement to hold bicultural rights. So indigenous peoples and local communities are called to be sustainable and to remain sustainable. Now, this is great if we think that indigenous people and local communities are stewards of the earth. However, we need to be careful not to fall for the noble savage trap and to consider that all indigenous peoples are in the position to be stewards of the earth. They might find themselves in a condition in which they just can't at the moment. Or they might find themselves in a position in which they have other priorities, and therefore actually being called to act as stewards of the earth at a level that is higher than the rest of the humanity might actually appear quite problematic. So falling for the noble savage trap would tell us they are always sustainable, they will always be sustainable. But actually, we need to recognize that they are holders of their own needs, desires, and wills. And therefore, we cannot construe them as, construct them as always pacific friends of the earth. Otherwise, it is an imposition from the outside. So now what we find ourselves with biocultural rights is a set of rights that are rights with responsibilities towards nature. They are, in other words, environmentally conditioned human rights, which seems great for our purposes. They are what we were talking about as a first attempt to ecological human rights. However, we definitely, keeping in mind the noble savage problem, the noble savage myth problem, we need to be careful. And actually, in the literature, after a first moment of enthusiasm about biocultural rights, there was a rise of the very politicized debate about indigenous peoples and the fact that they have indigenous peoples' rights. Indigenous peoples' rights are grounded on the intrinsic value of indigenous peoples and are not environmentally conditioned. Indigenous peoples' rights have been fought for very strongly by indigenous peoples' representatives to protect indigenous peoples, regardless of whether and they don't entail their duty to be and remain sustainable. Of course, in many cases, indigenous peoples' rights are exercised through nature, through the living with biodiversity, through actually being stewards of the environment, but they don't require indigenous peoples to be so. And therefore, there was a strong call against the bicultural rights by saying, well, we're actually giving states a cheaper option. They can decide to recognize indigenous peoples' bicultural rights instead of by indigenous peoples' rights. There are more powerful tools that we fought for. And therefore, they were perceived as a potential threat for indigenous peoples' rights. And because they basically made among most vulnerable and marginalized members of society bear the burden of protecting the environment. A burden that might be incorporated into their worldviews and practices, as many times it is, but that could at times also become unfair, especially if imposed by the state according to incompatible visions and understanding of environmental sustainability. So bicultural rights can definitely be useful in certain situations for indigenous people. So for example, when they are denied their indigenous status, they are denied their indigenous rights, they might use bicultural rights, to fight for a different types of, protection, which is better than nothing, but they should still be treated as a second best option for indigenous peoples. However, I wanted to look at bicultural rights because they can give us some teachings about the idea of ecological human rights. The first teaching is the fact that the structure of human rights is not intrinsically, but only traditionally anthropocentric. It can accommodate nature's interest within their very foundation. It's just that we are not used to create their architecture in this way. The second is the fact that human rights address needs and interests that can hardly bend to other considerations without the risk of very high trade-offs in terms of suffering, violated identities, and lost lives. So we need to be careful when conditioning human rights also to environmental considerations. They are to be accounted for, but human rights are a very specific tool that it's very important to protect the basic needs. So biocultural rights could be taken as a starting point for the creation of new rights that welcome nature into their foundation, but that concern a wider group of people. So not just indigenous peoples, but actually, and this new idea of rights might not qualify as human rights, but actually as rights. So not fundamental rights. So they should not be there and substituting existing human rights, but actually being added to the different options that people have, requiring rights to their governments, to their local authorities, or to the international community. So we could try to move beyond bicultural rights, proposing a shift to focus on local communities, which were already included into the bicultural rights debate at the beginning, but they were not the focus of our discussion. So now let's bring them actually into the center and look at the local communities that are including, for example, non-traditional communities such as farmers or newly established eco-villagers or holders of sacred natural sites, or even engaged citizens. And recognize the fact that indigenous peoples are different subjects from local communities, because indigenous peoples have indigenous rights, local communities not yet. Local communities' rights at the moment are emerging in international law, and they are emerging as rights that are recognized precisely to those communities that do have a special relationship with the environment, which is in fact, we're talking about farmers' rights, or the UN Declaration on peasants' rights and other people working in rural areas, or pastoralist rights, or small-scale fisheries rights. These are all rights that are somehow related to the environment already. We could, and here I just I leave just a call. We could conceive these as rights for ecosystem services that could retain that there could be rights in return for protecting ecosystem services, for promoting conservation. There could be rights to property, including commons, to extra quota of natural resources, to seeds exchanges, to sacred natural sites. They should not be conceived as human rights, as I said, but as special rights to be obtained with a conditionality, only if you behave in a certain way. So in this way, we could conceive, and here I move to the closing, them as double foundations rights, grounded both on the interest of local communities, but also in the interest and the protection of nature. And they could become a possible understanding of ecological rights that could be implemented in ways that foster both humans and nature's interest. So res as an idea may help reconceptualize rights as embracing both human and nature's interest in the protection of nature, therefore thereby overcoming the classic anthropocentric, ecocentric dichotomy characterizing literature on human rights. Thank you.
네, 감사합니다.
Thank you very much. We were a bit overdue, so we have only 15 minutes left. So we can get into the discussion right away. I would like to invite the discussants and the speakers onto the stage. Dr. Kim, you're coming here frequently, so you can make it a little bit shorter. And probably, Dr. Kunu Kim can have some more time.
예,
Thank you, Dr. Hwang. You have a lot to talk about, but you cannot cover all the presentations. But we do not have a lot of time today. And Dr. Kim first. I'm Kim Jun-soo from the KAIST, Anthropocene Research Lab, and I'm a researcher studying along with Dr. Kim, and also I'm studying with Dr. Hwang. So I would like to tell you more about the relations between the more than human geography and also O's jurisprudence, and how we can have the mid-range or the middle range between the two disciplines. I have a small PowerPoint that I have prepared. And Dr. Kim pointed out whether the Earth jurisprudence can be a realistic approach or not, and what kind of methodology that we can choose within the community of the Earth jurisprudence. The more than human geography is now trying to find out a better way to make the discipline more realistic, and how best we can understand the research topic and expand the research topic and the scope of the research. Dr. An is now leading the Biocracy Lab, and there is interrelations between the biocracy and biopolitics. So what matters is how the new politics should be defined, and whether there can be any prerequisite or whether there can be any further implications, and what kind of research should be made about the new ecological system or the new ecosystem. The more than human geography focuses more on the conflict and tension. However, Ewha said that other species are vehicle for the state power but also frustrate state ambitions. So we should think about what kind of relations or what kind of behavior is something that we should study. The nation between the nature and the state. Yes, there is a framework. And we can look at a state as a framing device. And in that case, the ecosystem can be a really small component, and we can take some strategic movement. As Dr. Hwang said, and there are some accumulations and the hegemonic project, so that we can bring the nature from the outside. This is one pillar in my PhD. The state nature formation was really anthropocentric state nature. However, on the other hand, we can have a different ontology. And with the non-human ontology, we can look at the capacity and the freedom of the non-human, and what can be the factors that help us understand the non-human, and what kind of knowledge can be generated, and how we can select the knowledge will become really important. In the territoriality strategy, the behavior of the species can sometimes go beyond the scope of a state. And there are various talks about the ontology. However, what I would like to tell you is there are multiple classifications for the states, settled down states and the even the colonial state. Ontologies perform themselves into words, and they can build upon the anthropographies that view ontology as a story. That's a kind of the story of the violence. Blazer said this is a political ontology which involves violence within it, and what can be the political issues within it. And Barat said that political ontology can clearly define what can be the unit of analysis. To have international relations politics, urban studies, and the critical border studies, we can look into some of the areas so that we can have the meso-level studies. Yes, international studies, urban studies, critical border studies. These are the key areas that we can take a look at from the perspective of the more than human geography. We didn't talk about the post-colonialism, And we can have some history viewpoint. You can see this lake located in China. The city name was Changchun, and that was the capital city for the Manchuria. They built trees to protect the lake. And at the time, to build this artificial lake, they had a huge ideology, and many people were working for this. And imperialistic projects were conducted to build this lake. Crosby, who wrote a really famous book, said, "This is a multi-species revolution. From the old state to the new stage, and from the old continent to the new continent, that kind of movement can be made, especially during the imperialism, and how that can be realized from the viewpoint of the East Asia, and what kind of heritage has been moving, and how the ecological impact has been made." And regarding this, many people are studying, for example, the movement of the insects and the bugs, and during the wartime, the history of the Jew, and there are various topics to study the more than human geography. The second topic is climate change and critical conservation ecology. What I mean is, as Professor Kim and Professor Koje said, but actually this is a little bit different from what you presuppose. The Holocene ecosystem should be protected, and there must be political and the policy tools. Recently, many evolution has been made, and many of the biological changes were made. However, this cannot be framed into the Holocene viewpoint. You can see this book, Wildlife, which was written by the person who studied the laws and geography at the same time, and he reviewed 120 researchers who are working for the field ecology study, and he underlines the importance for new framework. When we talk about the conservation, to which period should we go back, and when is the ideal period among the Holocene era? And that is one of the key studies of the more than human geography. And this is one of my research paper. And you can see the wasted water, and the water is now warmed. And when the water is warmed, a new species, the new fish, is now settling down because the water has been warmed. And this kind of tropical fish is now living in South Korea. The third topic is the movement of the species. And regarding this, I am studying how the bugs are moving from South Korea to North Korea, and how this movement can create the new order of the politics. Last but not least, we have methodology, how we can do it. First, between the Earth's jurisprudence and more than human geography, we should take some critical approach, and we should pay more attention to new phenomenon and new politics. We should come up with a new theory, new language, so that we can have a better methodology. That's it from me. Thank you very much.
안녕하세요. 저는 김건우라고 합니다.
Nice to meet you. My name is Kim Gon-ho. My specialty is legal philosophy, and I'm also involved in making policies for science ethics. I don't have enough time. As Mr. Kim mentioned that he actually complemented the previous presentation. If, of course, I'd like to talk a lot, but we don't have enough time. I'd like to point out only a few highlights. I'm a panelist, so I don't want to talk about my own research results, but I'd like to ask a couple of questions to the presenters. I'd like to ask the first question to Professor Hwang. You talked about gentrification and also Juche ideology, but I'd like to ask you questions about whole. You talked about more than geology, and that is also the research subject that you've been delving into. As a theologian and also philosopher, I'd like to ask you about the foundation of the more than human geography. The reason I want to ask you about the ontology about the human geography, the reason is because that ANT, or actor network theory, new materialism, these concepts are emerging. The connection between human and objects, and this new movement refuses the privileged status of human beings. And I think more than human geography, your presentation is also part of the ANT. ANT is also part of the there are also a great room for consideration in ANT. Mr. Hwang mentioned the commons, mentioned about the commons at the end. The commons are not necessarily dealing with humans only, but assets. And the commons are posing alternative views to not only humans, but the whole non-livings. But commons, to my understanding, is the concept that encompassing not only humans, but also non-living beings. So, Mr. Hwang, can you share your theoretical foundation about more than human geography? Okay, I don't have enough time. And Professor Sayeva? Should I call Professor Sayeva? Sayeva or Sajeva? Sorry for my pronunciation. We received your script, and initially your work was about do we need Earth's jurisprudence, and I was a little bit stunned because the article that we read and your presentation was a little bit different. So we were able to know the indigenous people and their rights, and then you put into new perspective, into cultural perspective. So thank you for sharing your new perspective on indigenous people and their culture. If I share my ideas, then it would take too long, but I'd like to highlight one interesting point. In the legal theory, the Earth's jurisprudence didn't get much attention. There are only few people who are interested in Earth's jurisprudence, but I think Professor Jajeba are such a rare gem in this research, so I was really happy to see your work. I've been thinking why that the mainstream legal scene doesn't include or pay deserved attention in the Earth's jurisprudence is maybe it's a new concept, and also it's because I think your paper shares a little bit about this theoretically and also philosophically, that the Earth's jurisprudence embraces heavy issues. When I first encountered Earth's jurisprudence, I thought that the subject was too heavy. Your article elaborated a little bit on the difficulty or the heaviness of Earth's jurisprudence. The discussions about the rights. The Earth's jurisprudence is very destructive and it contains very significant implications. It has, it upholds the rights of nature, and it encompasses the rights not only for human, but also it also upholds the rights not only for the current generations, but also the future generations. So that the human-centric approach is transforming into nature-centered approaches. So that is very dramatic. But theoretically and also philosophically, there is a burden for us to elaborate the theory. So Colin or Thomas Berry pioneered the work. However, their theory framework is basically about the rights of discussions about rights. The modern system, they stick to the modern system, and they are expanding the subject and also the object. So metaphysical justification and the conceptualization, and that is the burden of Earth's jurisprudence. The existing law has the authority, and in the past, the law came from the God's rule, and also the law came from the natural law, the sacred law. But as you know, that in the modern era, that we uphold the human values, human ethics, human morals. But in the Earth's jurisprudence, that we tend to go back to the nature. How can we go back to, or how can you retrieve the authority of law, the glory of the past? In the past, the human beings needed the justification of God, but we abandoned God to uphold our own reasoning. And now our own reasoning is we're trying to replace our reasoning by the natural rights. Sorry that I talked too long. So from the legal theory, in many discussions about the personhood and in the relationship between the subject and the object, that we are placing nature in the center. So the framework is in line with the existing framework. Since you are the legal theorian, I'm sure that you know what I'm talking about. And it's also shown as the conventional framework is because the law is based on the legal and the human activities, and this law is preempting the human practice. So law is a self-contained and autonomous concept. However, we do have conventional framework in the law sector. The reason is because that we have failed to grasp the relationship between the nature and the human. Some presenters this morning talked about it, that the law is regulating human behaviors. Also, the human beings are creating legal frameworks. So we need to transform the legal frameworks. This is a very dramatic request. I said I'm going to make a brief comments, but actually it took longer than I thought. I'd like to go through I went through the highlights in your article, and in the online presentation that you talked about indigenous people, their rights and how to protect their rights, and you introduced biocultural rights to protect their rights, indigenous people's rights. So we are actually encompassing more subjects to give rights. The question I'd like to ask Professor Ewha is bioculture rights. How the bioculture rights are different from the existing rights. I think you mentioned at the end of the presentation. How can you tell me what's the difference between the existing ones and the natural bioculture rights?
So we are well overdue. So what should I say? As we have the international guest, Dr. Ewha, and you can take the role. And there was a comment that the Earth jurisdiction or the Earth jurisprudence is a kind of still a conventional framework. And if you have a comment and you have just 1 minute, please.
Thank you. And sorry about the change in the paper. The change was done a while ago, but I see it was not well implemented as thought. So thank you very much for introducing the other paper that I had written. I think that you pointed out the main problem at the end of the day, because Earth jurisprudence suggests this great idea of actually recreating and relearning to talk to nature, but the problem is that sometimes it goes back to natural law theories, which is something that the state and the way we conceive the law today cannot really easily accommodate. And I think this is why, as you were mentioning, there are not many legal theorists that work on Earth jurisprudence, because for some of them it feels like it's a going back. Well, I think that it is something we need to acknowledge, but we can learn from it and try to enter a different discussion. Was this the discussion about democracy? That is what was faced with before with the previous speakers, because it is, at the end of the day, a restructuring of our understanding of democracy that should not leave away the importance of peoples as deciders, as self determinants of what is going to happen, but should accommodate also science in ways that at the moment are not very easy to find a balance with the democracy's part. So how can a better knowledge of science can actually help make better decisions also from the ground, from peoples and through democracy? Hence, I stop here because I think my minute is done.
네, 감사합니다.
Thank you. And Dr. Kim thinks that it's too much focus on the discourse about the rights, and it is going back to the natural law theory. God, reason, and nature are like the source of the legal framework. We are going back to the nature, and he said that there is a burden when we are going back like that. And Earth's jurisprudence is now envisioning a new set of the natural law. And Dr. Kim talked about the meso-level approach, and he talked about the history, and he talked about the colonialism and post-colonialism, and that is something that we should understand better. And I hope that we can have another session to discuss further. And please understand that we are well overdue. And without further ado, I would like to conclude the day 1 of the conference. Thank you.